Hello and welcome to the marathon session of ECIPL. In this session, we are going to exclusively focus on part B of the syllabus, which carries 40 marks. We have made an exclusive video on important chapters in ECIPL. In that video, I have clearly told the significance and importance of part B of the syllabus in passing the subject ECIPL. You can watch the video, the link is in the description. So let's directly get into part B of the syllabus. Before going into the concepts and seeing what are the topics that are provided in the syllabus, let's discuss what is intellectual property law. Earlier, we had laws for protecting tangible properties, for protecting physical properties. For example, if there is a house, nobody should enter the house and do theft. Nobody should do burglary. If there is a land, nobody should trespass the land. If there are products kept in the manufacturing unit or a godown, nobody should damage it. Nobody should tamper it. Nobody should steal it. Those are the kind of laws which are prevalent in the market. But what about the laws for protecting the intangible property, something that we cannot see, something that cannot be identified, right? For example, there is a product, okay? That product is being bought and sold in the market because there is a need for that product. There is some problem and that product is solving that problem in the market, right? Now, imagine the product is in existence. What about a problem which is existence but there is no product to solve the problem, and you as an entrepreneur have identified the problem, have identified the solution, and you yourself have invented a new product. You have given a solution to the people, you have given a solution to the society for the problem that they are facing. Now you have developed that product using your intellectual mindset, your thoughts, your brainstorming sessions, years of hard work. You have taken 10 years to develop that product. And imagine the same product can be manufactured by anybody and they can make profits out of it. It is your product. You are the one who have invented it. You are the one who should have exclusive right of selling that product. You have done all the hard work. You have put it out in the public domain. Immediately next day, if somebody else is allowed to manufacture the same product and sell it in the market, what is the point? Right? That is when we realize that it is not only the physical properties that need protection, but also a human mind needs protection. You are putting in a lot of hard work, slogging years together to develop a product which is solving a huge problem in the society. That kind of products also should be protected. Your thought should be protected. So the person who is creating a product through his intellectual mind should also be given some kind of protection, and that protection is given through intellectual property laws. What is intellectual property? Any property, any product that has been developed through the process of mind is called as intellectual property, and the laws that protect these intellectual properties are called as intellectual property laws. What are intellectual property laws? I have given you a brief explanation. For example, you have created a tune of a music, okay, music tune you have created. You should be given the exclusive right of using that tune. Somebody else should not use. You have created a story. It is your story. You have written the story. You should have an exclusive right of using that story in any form that you want, and nobody else should be permitted to copy your story. Right? You have a medical condition. There is no device to, let's say, track some kind of medical condition. You are the first person who has created a device which can track and regularly monitor some kind of medical condition. That product needs protection, right? How have you developed it? What is the technology? Right? That needs protection. So these are all various kinds of intellectual properties, and this is what we call as patent, copyright, trademarks, designs, geographical indications. You have plant varieties, right? A lot of newer things are coming under the ambit of intellectual properties. So these are all the kind of properties which require protection, and that is why we have created a new avenue called as intellectual property laws. In intellectual property laws, what are we going to focus on? We are going to focus on something called as IPR, that is intellectual property rights. what are the rights that have been granted to the creators of these intellectual properties. So this is the basis of the subject. We are going to identify what is the intellectual property, what are the various kinds of intellectual property, and whoever has created this intellectual property, what are the kind of rights that are going to be given to these creators. This is the basis of our part B of the syllabus. If you see part B of the syllabus, you have 6 chapters that you have to cover. Chapter 1, that is lesson 15. Okay, basics of intellectual property right. What are the laws at international level? What are the laws at the national level? Then these are all the various kinds of intellectual properties which have been specifically dealt with. You have law relating to patent, trademark, copyright, geographical indications and designs. 5 kinds of intellectual properties we are going to focus on, right? So let's directly begin with lesson 15, that is the basics of intellectual property rights. I've already told you what is an intellectual property, but let's go through the definition that has been provided. Intellectual property is nothing but a creation of human mind. It is what thought process, what intellectual capacity of a person is being utilized in creation of any kind of product, right? That is what they say. Intellectual property is a creation of human mind and human intellect. You are intelligent enough to lead to the generation of a new technology. Now AI is in the boom. Who had thought about AI being brought into existence? Who thought that artificial intelligence can actually help human solve their day-to-day problems, can do their work quicker, can do their reduce the workload, right? So that is the creation of human mind. People have thought about it, they have developed technology around it. So that itself is intellectual property. Whenever you are creating a new product, using your brain, putting your brainstorming sessions and intellectual capacity and developing a product, that itself is intellectual property. Again, it refers to inventions, designs, literally, that is copyright, artistic work, symbols, trademarks. All these are various categories of intellectual properties. Now, what is an intellectual property right? We have seen what is an intellectual property. Any property that has been developed by the creation of a human mind is called as intellectual property. But what is a right? Your intellect, whatever you have thought, whatever hard work you have put in developing a product, that should be protected. And to protect that, what is required? We should give the creator of the intellectual property some kind of exclusive right. What is the exclusive right? Because you have generated the product, you have invented the product, you have created the product, we are going to give you the exclusive right to use that particular product. We are going to prevent the others from using your work, prevent the others from utilizing what you have done. If you have invented the product, only you will have the right to manufacture that product. Obviously, for a certain number of years, till the protection is there, till then you will be the only person who is going to manufacture and sell that kind of product. Similarly, if it is a copyright, same thing applies. You have written a story, you will be having the exclusive right of using that story. You have made a breeding, okay, plant breeding is also there, variety of plants are there. If you have generated a new kind of plant, you will have exclusive right of dealing in that kind of plant varieties. So we are going to give you an exclusive right to use that product and also prevent the others from using it. In addition to that, if you want to allow the others to use that product, you will be having a right to negotiate for the payment, something that we call as royalty. We have generated the product, but we are not in a position to exploit it commercially. We are not in a position to maybe put it out in the market. We have only invented the product. Now we are going to give the right to some third person to put our products in the public domain, to sell our products, but subjected to the payment that it is my product. I am somebody who is capable of doing a lot of technological work. I have the intellectual capacity of inventing new things, but maybe I'm not very strong enough in marketing the products. I'm not very strong enough in selling the products. So what I'm going to do, I am going to manufacture a product, invent a product, I am going to get a patent for my product, and I'm going to give the right to a third party to use my products to put it in the public domain, subject to a condition that whatever product he is going to put in the market, I am going to get a part of the payment for that. That is called as royalty. That is called as it is my product. I am only assigning the work of putting the product in the public domain to a third person. So two kinds of rights are going to be given. One is exclusive right to use that product only by you. It is going to prevent others from not using your products. And secondly, if you want to allow somebody else to use your products, you can do so subjected to the payment that you should receive, because it is your product, you are the creator, and you should receive the payment for the products that you have created. So these are the two major category of rights that are granted to the creators of intellectual property rights. These rights of the creators itself are called as intellectual property rights. Next. What is it? It is nothing but a legal privilege. Earlier there was no recognition because there was no concept of intellectual property laws. But now that we have understood the importance of intellectual property rights, we have given the legal privilege to the inventor or the creator of the intellectual property to safeguard his invention and creation. This is what I have already told you, but it is subjected to a fixed amount of time. If you talk about copyright, copyright is on your books, your publications, your song, your music. What is it? It is 60 plus life. That means till the creator is alive, till he is living, for the entire life, his copyright is protected. Even after that, 60 years after his death also, the protection is going to continue. So the time is fixed for how long we are going to give you protection, right? It is already fixed. So for that duration of time, you are going to be protected. You are going to be given that exclusive right to use your invention, to use your creation. This itself is known as intellectual property laws. Coming to the privilege. The privilege is granted for a specific limited time, giving the exclusive permission to the creator to use his or her work. This is very, very important to reward creativity and human endeavor. If we are not giving the recognition, if we are not giving the rewards, ultimately whenever any person is working in whichever industry, whether it is you are an employee somewhere, whatever, you require some kind of appreciation, require some kind of rewards, we require some kind of motivation to do better. So if we are not giving protection to the inventions that are created, why will people work on inventions? Why will people work on creativity? When people are exploiting their work, they are not able to safeguard their own product. Why will somebody waste their time in making more inventions, making more creativity? So that is why they say that for rewarding the people who are using their intellectual capacity, we should give them some kind of reward, and this protection itself is the reward, so that they can do better and make more inventions and more creations. Next. Coming to what are kinds of intellectual property, there are various kinds which are now being brought under the ambit of intellectual property, but the common ones we are going to deal with: copyright, you have patent, we have trademark, we have trade secrets, we have geographical indications, and we have designs. Out of this, 5 are there in your syllabus that we are going to cover. What is copyright? Copyright is for any kind of publication, your music, your artistic work, theatre work, songs, stories, all that comes under copyright, that is protected. Patent is for a product. It can be either a process patent or a product patent. How you have manufactured a product, the process of manufacturing itself is protected, or ultimately the product, the final product that you have manufactured, that product is protected. So 2 kinds of patent are there. So that is for invention, for technology. Trademark is nothing but your logo or mark, the brand image that you have created, that is required to be protected. You have a lot of logos. Just by seeing that one logo, you are able to identify which company it belongs to, right? So that is trademark. Trade secret is confidential information that is there. Because you are an employee of an organization, you have access to some sensitive information of the company, so that becomes trade secret, and that should be protected. Geographical indication is you have a location, that location is famous for some kind of product. For example, Mysore is famous for Mysore silk, right? That recognition should be given, that privilege should be given to that particular product, that genuine, original products are coming from this place and this is the product. That is geographical indication. And industrial designs and right is creativity. You have, let's say, this pen. A pen if you see in the market, there are lakhs of pen and each pen has a different design, right? So the product is the pen, but how it is crafted, how it is designed is the design, and that design also should be protected. Same thing goes for cars. There are so many cars. The work of car, function of the car is same, carry the passengers. It has 4 wheels, it is going to carry the passenger, it is going to move. But the outer structure of the car is different for every car. So that design of the car should be protected. You have multiple watches. What are no, every watch's function is the same thing, to show you the time or to show you the date. Apart from that, what is the design, what is the dial, what is the color, what is the metal that is used, how is the metal design, that also requires protection, because that is creativity. So these are the various kinds of intellectual properties that are prevalent predominantly. Other things are also brought into existence. Coming to the nature of intellectual property, mark it as important. It could be a possible question in the exam. First one, again, we have already discussed this. It is more about intangible rights over tangible property. We are here not trying to protect the physical properties. We are not trying to prevent from stealing, from damage, from tampering. No, we are trying to here protect the human mind. We are trying to give protection to the person who has created a new product, who has created something that is creative. Okay, so we are going to give protection to that. So it is more of intangible, something that we cannot see. We cannot see your how much intelligent you are, what is your intelligence quotient. We cannot see that. You have developed something, so that should be protected, right? We give protection for intangible ideas like intangible properties like ideas, inventions, science, etc. Next, second is right to sue, right? Intellectual property right is a right, like you have a right to property. That property after the death of the owner is going to go to the legal representatives, or if he's already written that this should go to so and so person, it is going to be given to so and so person. It is capable of being inherited from someone. Whatever rights we have with respect to physical properties, with respect to tangible properties, same rights are also vested on intangible property, where you have a right to inherit the property, you have a right to purchase the property. Suppose I have developed a patent, right? I have created a product, I have got a patent in my name. Now I want to work on one more new invention. I can sell my patent to some company for a huge sum of money. It can be purchased by companies or anybody for that matter. It can be gifted, it can be sold, licensed, entrusted, or even pledged. So whatever rights are associated with physical property, same rights are also vested with intellectual property. And because so much can be done, obviously there will be some kind of dispute associated with intellectual property, and that is why if there is any kind of dispute, we also have a right to sue for that particular dispute that has arisen. Third category of nature is rights and duties. We know that intellectual property laws are there. Because there is a law, we have brought the laws because we want to give some kind of protection to the creator or the inventor. So we have to give him the right. I already told you two kinds of rights are there. One is exclusive right to use that property and preventing the others from using your property. And secondly, to get payment if somebody else is going to use your product. So those are the rights. But wherever there is a right, there is also some kind of obligation that is created. There is some kind of duties that are established. Same thing lies even with intellectual property. You have rights, but you also have obligations of continual renewals, because it is subjected to a timeline. Suppose we say that your protection is for 10 years. After 10 years, you have to renew. If you want the protection to continue, you have to renew your protection. So their continual duties and obligations arise. And also when you have a right, you should not go beyond. You should not exploit your own rights. You should not misuse your own rights. That also is the obligation that is established upon the inventor or the creator. You have two kinds of right. One is positive right, where you have the sole authority. That is nothing but the exclusive right to create, copy, sell, exploit your own work. Nobody else is permitted to use your work. And negative right is the thing that we are preventing the others from using it. We are giving you exclusive right. Only you can deal with it. But a negative right is also created, that when we are giving you the exclusive power of exploiting your invention, using your invention, the others are prohibited from dealing with your products. Okay, so they cannot use your invention and make profits. So you have a positive right as well as negative right, where the others are prohibited from using your inventions. Next kind of nature is coexistence of different rights. What does this mean? It means that if I have a product, that product can also have a trademark, that product can also have a design protection, right? It can also have a patent protection. So one product itself can be subjected to protection under various different categories of intellectual property laws. For example, there is an image. For that image, you have taken a copyright, and the same thing for the invention itself of that particular product, you can take a patent. Same thing, there is a design, you can get a trademark for that design along with the design protection under the Designs Act. So one product itself is allowed to be protected under different categories of intellectual property laws. Exhaustion of rights. The doctrine of exhaustion applies even to intellectual property laws. It's nothing but till you have a right, it is you who are going to exclusively have the right to use the product. Once the period of protection is over, once the product comes into public domain, when it is sold in the market, it is going to be available for anybody. The only advantage that you are going to have then is the monopoly that you have created. Suppose you have a protection for 30 years for a patented product. For 30 years exclusively only you are dealing with that product, only you are selling that product. So people over the 30 years period have identified the product with your company. Oh, this product means only this company selling. You have already created a brand name, you have already created that market for yourself with respect to that product. Now after 30 years, in the 31st year, even if some other company tries manufacturing the same product, they can manufacture and sell, but you already have a bigger share in the market. We have given you that right to creating a market share for yourself. So once the period of protection is over and it comes out in the public domain, then your right is exhausted. Anybody else can also utilize the product. So the duration, the time limit is also very, very important when we talk about protection of intellectual property laws. Last one is dynamism. That is nothing but, like I told you, everything is evolving, everything is growing by the day. Earlier we didn't even recognize intellectual property, then we started recognizing industrial property and copyright. In that, various variations came into existence. So with the passage of time, newer kinds and continual improvement is there, because of which newer things are being added to the list of intellectual property rights scope. Earlier only patent and copyright was there, now trademark is there, design is there, trade secret is there, plant variety is there. So many newer things have been added to the ambit of intellectual property. That is nothing but the industry is growing. It is a dynamic industry, things keep changing, things keep improving, and that is what is the nature of intellectual property, because that is how the mind functions, right? So we have now biopatent, software copyright, plant diversity protection. These are some examples of newerly developed intellectual property. Coming to classification of intellectual property, again a very important topic. We have seen the kinds, okay? What are the kinds? Copyright, patent, design, trademark, trade secret. These are the kinds of intellectual property. Now, before going into the kinds, there is classification that is very important. So there are two things that you should know. First classification is copyright, okay, and second classification is industrial property. Under industrial property, you have different segments of intellectual property, okay. Copyright is one category, okay. In that you are going to protect the expression of your ideas, and it applies to technology, scientific work, art, literature, music, audiovisual, technology. How you are doing the coding, writing of codes, okay, that is protected. Technology, scientific work, art, your songs, your music, your artwork, your sculptures. If you are involved in engraving, that is your art. Your painting, that is protected. Literature, you're writing books, you're writing stories, you're writing lyrics, all that is protected. Music and audiovisual, your tune, music tunes, all that is going to be protected. So that is copyright, where we are going to give protection to the expression of ideas, okay, that is copyright. The second category of classification of intellectual property is industrial property. Under industrial property, we have different kinds of intellectual property, that is patent, trademark, and trade names, almost similar. biodiversity, plant breeding rights. These are all going to give the holder of the right, that is the creator of the right, to have an exclusive right to exploit the invention and profit from it during the protection period. So the patent is a part of industrial property, right? So what is the intellectual property? Broader term is intellectual property. In that you have two classification, one is copyright, then is industrial property. Under the industrial property you have different kinds of intellectual property, that is patent, trademark, plant variety, biodiversity, all that comes under the ambit. So this is the classification of intellectual property. Coming to the regulatory framework, in India we have enactments for protecting each category of intellectual property. Suppose you want to protect a patent, we have the Patent Act 1970 that is going to regulate it. For trademark we have Trademarks Act of 1999. For copyright we have Copyright Act of 1957. For designs we have Designs Act of 2000. For GI we have GI Act of 1999. So these are the 5 things that are covered in the syllabus. So I've kept it under the ambit of the syllabus. Similarly for plant variety we have a different enactment. So what are the kinds of intellectual properties are there? For regulating and governing each one of these categories of intellectual property, we have a different enactment. So this is the overall regulatory framework for intellectual properties in India. Now coming to the international level, why? Now the main global impact came into existence when liberalization was brought into force, when products and services are moving borders, when international transactions are taking place. At that point in time, how are we going to protect the products? How are we going to protect the creators? How are we going to protect the inventors? So that is when international laws will become necessary. You have the United Nations, and we know that they are looking at the laws globally, right? When the transaction is taking place between 2 or more countries, what should be the law? How should we protect? How should we govern? There should be certain kind of uniformity in the laws across the various countries, so that the dispute reduces. These kind of laws are created at the international level by various organs or associations of United Nations, and whatever law has been created at the international level, they are going to give you standards, minimum standards of how the law should be. It is left to the country individually to adapt to those standards. So how does it function at the international level? Let's keep it as United Nations. For example, if you're exclusively talking about intellectual property, we have World Intellectual Property Rights Organization, and we have the TRIPS agreement that has been signed, okay, in relation to intellectual property. So if you are a member country who has signed to this TRIPS agreement, in this they are going to give you the minimum standard of what should be the law for protecting a patent, what should be the law for protecting various kinds of intellectual property right. They are going to give you the minimum standards. Now whoever is the member country, whether it is India, whether it is US or any other country, they should abide and comply with the international standards. So they are bringing some kind of uniformity in protection of intellectual property laws. So this is the overall ambit. There is an international organization. They are looking at bringing uniform laws across the globe, so that countries will have similar laws to a certain extent, so that when international trade and international transactions are taking place, there is reduced topic for disputes. So that is the overall ambit of the international perspective. Let's see with respect to intellectual property laws, what are the provisions. So you have firstly the General Agreement on Trade and Service. This is again primarily required, because until and unless the international transactions are not permitted, it is very difficult to deal in the goods and services cross-border transactions. And this was the first agreement that allowed the global trade and services and gave some kind of legal binding multinational regulations governing the transactions between 2 or more countries. It was established through the Uruguay round negotiations and brought into effect on January 1995. What is the objective of GATS? Again, predominantly, like I told you, they wanted to permit cross-border transactions. They wanted to bring a lot of liberalization, right? It wanted to establish a trustworthy and reliable system for international trade regulations. They wanted the international trade to be regulated. Proper rules governing the transactions was required. That is why we entered into this particular agreement. It guaranteed non-discrimination among participants. What is non-discrimination? there are various countries. All the countries together are coming and signing an agreement. They did not want that any one country should be given preference over the other country. Favorism should not be there. No kind of discrimination should be done between different countries is what they established. They said that however developed you are, whether you are developing country, whether you are an underdeveloped country, no, we are not going to discriminate between the categories of the countries. If you are a member to the agreement, if you have signed yourself as a member of GATS or as a member of TRIPS, you will be treated equally. No kind of discrimination is going to be done. Oh, US, it is the largest country, it is the country which has a lot of hold globally. So we are going to treat US differently, we are going to treat India differently, we are going to treat Pakistan differently, or we are going to treat the UK differently. No, if you are a member, everybody is going to be treated equally. Then boosting economic activity through policy buildings and facilitating trade and development through progressive liberalization. That is what they wanted. More and more international transactions to take place, more and more international trade to take place. And because they wanted to promote international trade, if there are no rules and regulations governing the international trade, it becomes very difficult for people to have confidence and enter into those transactions. So they laid a standard by entering into the GATS. Next, functioning, it has 3 levels and 4th is a special element. They have basic primary text which contains the basic principles and obligations. What are the principles when you are entering into transaction internationally? What are the basic principles you should keep in mind? What is the obligation of the importer? What is the obligation of the exporter? What are the basic requirements of law that is given in the primary text? Then is individual nations' explicit commitments to acknowledge, to allow the access to their markets, very important. Now, we have, unless and until there is no enmity involved, there is no war going on, you cannot block access. Now, China cannot say that we are not going to allow Indian products at all, or India cannot say that we are not going to allow China products at all. You should allow access for the market to other countries. You cannot block your country, because we are talking about international trade, we are talking about liberalization, we are talking about more and more important exports to take place. If you are restricting the market, you are not allowing the others to give their products in your market, then the international liberalization is not going to take place. And they say that we are going to create a commitment on the countries that they should open their market for the products of other countries as well. That is one obligation that is created. And next, it deals with the rules for particular sector. Again, the products are sector wise, agricultural products, defense products, manufactured products, for different categories. So for different sectors, we have different laws, different rules and regulations. So that is provided under the annexure. So you have basic rules that is applicable for any international trade. Then sector wise rules and regulations are there depending upon what is the product and which sector it belongs to. Then we have created an obligation on the countries that you should keep your market open for the products of other countries. And lastly is the special list. This is the one that I was talking about, where we talk about non-discrimination. The most favored nation principle with non-discrimination clause, that all the member countries should be treated equally. No one country should be given preference over the other. Don't discriminate any country. So these are the basic principles upon which GATT relies. Now, pillars, again not very relevant. They are mainly talking about bringing openness in the industry, bringing openness in the international trade, and predictability of pertinent rules and regulations. Because we are talking about international trade, how we are going to bring that openness? What are the rules, regulation? We have already seen the 4 principal elements on the basis of which the GATS is functioning. So that openness is required to be brought. That is one pillar. And next one we want to have progressive liberalization and subsequent rounds of talks. We want more and more liberalization. These are the 2 basic ideas on which GATT is functioning. Next, certain provision of the General Agreement on Trades of Service. Basically, it is concerned for developing countries. Developed countries are already doing well. Now, how the developed countries can help the developing countries? How can we help the developing countries reach higher stages of economic development? That is only when we help them. When we help them allow their products into the other countries as well. When we bring liberalization, the developing countries can sell their products, export their products to other countries. So we are going to impose a obligation on the developing company to exercise the rights that are created under this obligation of exporting the products, and we are going to also create a right on the government that they are required. It is the government of the individual country level. If we are talking about India, India is a signatory. Now, India's government is obligated to make rules, regulation, policies as per the international standards to fulfill the policy objectives at the national level. You have entered into an agreement at the international level. Now, how are you going to incorporate those laws at the national level? That becomes the obligation of the country. At the national level, you should be ensuring that you are compliant with the international standards as well. So, one is on the developing country to utilize the right and make the proper laws so that you can be at par with the international level. Next, preamble to the agreement. Again, it is basically to show the growing participation of developing nations in services and trade. Next, Article 4, it requires the members to negotiate specific commitments regarding, I told you, they have set rules, principles, and for that they have imposed certain kind of commitments. What is that? The commitment is for the improvement of developing countries' access to distribution channel and information networks. So the developed countries should help the developing countries by giving them the distribution channel, allow their products space, give them space. Okay, that is first one. Strengthening of developing countries' domestic service capacity and liberalization of market access in sectors of export interest to these countries. Same thing, it is all revolving around the same thing, that we should allow developing countries to grow. For that, their exports should increase. For their exports to increase, we should strengthen their developing capacity. We should strengthen their domestic capacity to manufacture more products and give them the channel to the market. All these things put together will help in liberalization and helping the developing countries achieve the market share. Next, the fundamental principle of GATT is in the idea of progressive liberalization. We have already discussed the concept of liberalization. That is one of the primary objectives of entering into GATTs. Now, they have also special provisions made for developing nations. Again, not very relevant. Mainly, it is only for economic integration of the policies, balancing the payment limits, and control who can access and utilize the mechanisms. Basically, they want to help the developing countries get the market share in international transactions. That laid the foundation for liberalization, and that laid the foundation for international transactions to take place. Now, international transactions were permitted through GATTs, rules, regulations were brought into force, principles were laid down. The next question is, what about the transaction where intellectual property rights are going to be involved? What about those transactions where there is a dealing in intellectual property? Then how are we going to undertake the transaction internationally? You have maybe domestic laws to protect within your country, but what about your intellectual property going to some other country? Which law will be applicable? How are we going to have the standards? For that, we have international laws with respect to intellectual properties, which is predominantly laid by the World Intellectual Property Organization. It manages and administers the intellectual property rights globally, right? It is the organization which oversees the intellectual property at the global level. It is the United Nations organization. It is devoted to using intellectual property as a tool for creating and fostering innovation and creativity. It wants to promote people, it wants to encourage people that please spend your time in innovation, spend your time in creativity. We are there to protect, we are there to oversee the intellectual property. You please look forward for innovation and creation. They want to foster innovation and creativity. It was founded in 1970 at the Geneva. Geneva is the location, Geneva Convention. Mission from its member states. Again, they want intergovernmental cooperation. The governments of two countries should cooperate. The member countries of WPI should cooperate with each other to bring about a standard protocol for protection of intellectual property laws, and cooperation with other international organizations. Like I told you, UN is United Nations. It has various organs. It has various sectors. For example, intellectual property, we have the WIPO. Similarly, for other sectors, they are going to have different organizations. So, each one of these organs of the United Nations should come together for achieving the objectives, and that is what is the expectation from the member state. When we say member state, who are the member state? Whoever is a signatory to the WIPO, whoever has agreed to comply with the rights obligations, whoever are ready to sign the agreement, they are called as the member states, and whoever have entered into being the member of WPIO, it is the obligation on those countries to give cooperation at the international level, and also the expectation is from the other organs of the United Nations and other departments that you should work towards protecting the intellectual property rights. Next, goal of WPIO, we have already seen they want to foster innovation and creativity. For that, we have to give them the creation of fair and efficient international intellectual property system. If the how we are going to register patent, how we are going to register a trademark, what is the process of registration, what is the system of protection. If your property is being infringed, you have the exclusive right, but somebody else is using your product, how are we going to give them the protection? What is the system in place? What is the procedure? What is the right? What is the protection? How are you going to deal with infringement? One system is required to be established, and that they have to have a fair and efficient system, and the responsibility of developing the system lies upon the WIPO, and they want to do this for the benefit of all the nations' economic, social and cultural development, because more inventions, more patents, more products are being brought into existence, more creativity is there, that is ultimately going to lead to the development at social level, economic level as well as the cultural level. So, this is the objective of WPIO, where they are promoting people, encouraging people to do more and more innovation and creativity, thereby promising that we are going to give a proper system for you so that your rights are not infringed, and it is going to benefit everybody at the development stage. Next, aim of WPIO is creating a fair and open worldwide intellectual property law system that encourages innovation, rewards creativity and advances economic growth. It is similar, all the objects, the aim, goal, everything is put together, is very similar, just the terminologies are different. They want to promote more and more people to look into ambits of innovation, creativity, okay, and they are going to give you a very good system where your rights are going to be protected, you are not going to be having infringements, we are going to give you reward by giving you the protection, and along all this you are going to help the country in development. Services provided by WPIO, again they give a global patent filing service, and they provide registration services for trademark, etc. So, they are developing the services of what should be the structure of registration process, right? They want to lay in place a system. That work is done by WPIO. They are going to give the standard. The same thing can be incorporated by the member countries at their country level national laws. Next is role of WPIO, again assisting newer systems and evolving, like law cannot be stagnant, it cannot be static, it has to change, it is dynamic. With the change in the atmosphere, with the industry change, technological changes, even the laws have to change, even the registration process might have to change, even the kind of level of protection that is required to be given has to change. So, that is the continual work of WPIO, where they have a role in continuously working towards the betterment of the intellectual property system. How we are giving protection, how we are giving registration, how we are going to give the rights, what kind of rights are given, all this is continuously required to develop, and that becomes the responsibility of the WPIO to give the assistance in newer systems, in newer intellectual property rights. Coming to WPIO, what does it work on? Predominantly 4 things. It gives services. What is the services? It gives you the system of how to do the registration and how to get protection internationally. In relation to that, also if there is any kind of dispute that is arising, how to solve those disputes, those kind of services are given. It gives the law, it gives the basics at international level, what is the law required. That has to be developed at the national level by the member countries. Infrastructure, it gives you building collaborative network and technological platform to share the knowledge and simplify intellectual property transactions at the international level. And development, it gives the capacity to in the use of IP to support economic development. It is going to help the country economic development to take place. So this is the work of WPIO for bringing advancement in the growth and application of intellectual property system at the global level. So they are going to give you certain services, they are going to give you the foundational standards of law, they are going to provide you the infrastructure, they are going to give you knowledge, they are going to help you and assist you in developing your country's intellectual property system, and they are going to also indirectly help in the country's economic development. These are the primary things or facilities that are provided by WPIO for bringing a global platform for intellectual properties. Now, coming to trade related aspects of intellectual property right, that is the TRIPS. WPIO is an organization. Within the organization, we have signed an agreement. What is it? Trade related aspects of intellectual property rights. So whenever a transaction is taking place where the product itself is an intellectual property, those trading activities, how are we going to deal with? Okay, for that we have an exclusive agreement at the international level. This is again signed by the under the United Nations WPI mechanism, where the member countries have entered into this agreement called as the TRIPS agreement. Let's see. Again, it establishes the minimum standards for IPR and its enforcement. What are the kind of laws that should be there for patent? What are the kind of law that should be there for copyright? What is the kind of law for trademarks? They've given you the minimum standard principles and guidelines, okay, and how you should enforce it. If at any point in time your right is infringed, how are you going to claim your rights? How are you going to claim for the unauthorized use of your products? So all that minimum standards are laid down in this TRIPS agreement. It is for the member countries to become compliant with the TRIPS agreement. This is the international law. This international law should be also incorporated by the member countries into the national laws. At the national level, the law that they are going to make, that should be compliant. For example, we have the Trademark Act 1999. That act should be compliant with the TRIPS agreement in relation to trademark related aspects. You have the Designs Act of 2000. That Designs Act should be compliant with the provisions of designs laid down under the TRIPS agreement. So it is giving you the minimum standards. If you want to transact internationally, you should be your laws should be up to the international standards, and the international standards are laid down under the TRIPS agreement. Beyond simply transporting the items across the borders, trade has developed to include also the value it brings to the society. Today's international trade involves a significant amount of value exchange through innovation, creativity and branding. It is not only about the product anymore, it is also about the value that is being brought about, and for protecting that value you need to have certain rules and regulations. So the development and trade policy increasingly heavily weighs how to increase this value and make it easier for knowledge rich commodities and services to move across borders. So India is known for a lot of ancient remedies, whether it is the use of turmeric, whether it is we have indigenous products, we have so much artistic work, we have so many different categories of handmade products. All these are exclusively there and prevalent only in country like India. Now we know that we have very traditionally rich products and services. We have a lot of unique products within the country, but those products are not given recognition internationally because people don't know about it as well. So we should create a marketplace where knowledge rich commodities can move across borders with ease, and that can happen through these TRIPS agreement. TRIPS agreement is essential for facilitating intellectual property trade. If you're trading internationally and your main subject matter is an intellectual property, then that is going to be facilitated through this rules and regulation of the TRIPS agreement, and it is settling the intellectual property trade disputes and giving the WTO members the freedom to pursue their own national goals. Right? And the agreement formally acknowledges the importance of intellectual property as well as trade. It is combining the trade aspects and intellectual property put together. What is the situation that is arising? That situation is going to be solved by the TRIPS agreement. Again, its main aim is to safeguard intellectual property globally, because we are talking about international cross-border transactions, specifically in relation to intellectual properties. What is the safeguard that is going to be given? who is the creator, who is the inventor, how we are going to give the protection to that person, right? That is going to be dealt with in this intellectual property trade related aspects of IPR. Required for member states, again, it's the same thing, that we are going to give you the minimal requirement that is there. We are going to give you the minimum set standards and principle. How you are going to incorporate that at your government level, at your national level, how we are going to incorporate and be compliant with the TRIPS agreement, it becomes the obligation of the member states to do that. That whatever law you have in your country for intellectual property, that should be in compliance with the TRIPS agreement if you are a member country of that organization. Member states' flexibility to draft their own policies in line with TRIPS. What does this mean? This means that at the international level, we already have given you the set standards, okay? We have told you that this should be the set standard, this is the minimum requirement of law, but we are giving you the flexibility that every country is different, okay? Every country's development stage is different, every country's products are different. You have to suit the law according to the needs of your country. We are giving you the minimum standards. You can change that. Maintaining the minimum standards, you can frame the laws according to what is needed in your respective countries, right? So that is what they say, that we are giving the freedom to the member countries to make changes, but they should maintain the minimum standards that have been prescribed. Next. So it gives the striking the right balance between the long-term advantages that are there by entering into the trade aspects of intellectual property, but that is also clubbed with short-term cost, right? So how you are going to manage the long term, immediately if you see, you have a lot of expenditure, but if you are able to bear through that expenditure in the long term, you have a lot of advantage. How you are going to balance that long term advantage with the short term cost, how you are going to balance that situation is what is going to give the member countries of TRIPS. So we have a lot of variety of procedures permitted by TRIPS, provisions such as exclusion, exceptions, members can lower the short-term costs, etc. So TRIPS has a lot of provisions which can help the member countries achieve this particular balance. For that, you have to be compliant with the TRIPS agreement. Dispute resolution is one aspect, one service that is being provided, that at international level, if there is any dispute with respect to a trade transaction where intellectual property is being involved and dispute arises between two countries, they are also giving you the provision of how to solve that particular dispute. So you have the provision, you have the mechanism which is accessible in case of trade disputes involving application of the TRIPS agreement. So wherever the TRIPS agreement becomes applicable and you have a dispute, the World Trade Organization mechanism can be used for solving that kind of dispute. There are 5 main topics that are going to be addressed in the TRIPS agreement. Generally, what are the general rules and fundamental ideas for giving the protection to intellectual property laws? What is the minimum protection criteria that should be satisfied by the member countries for protecting the intellectual property right? What mechanism should the members offer to defend those rights at their home countries? If there is a transaction at international level, 2 countries are involved. But if the transaction within the country, only the home country is there, how are you going to defend the rights? Interim framework for resolving IPR disputes and special transitional agreement for implementation of the TRIPS provision. So this is transitional only. When we are implementing the TRIPS for the first time, these are the things that have to be focused on. Again, not very relevant from exam point of view. Now coming to the national level. Till now we have seen the international level, we saw GATS, we saw the World Intellectual Property Organization, we saw the TRIPS agreement. This is the law at the international level. Now coming to the domestic level, that is national level, talking about India as a country, what have we done for protection of the intellectual property rights? Because we are the member country of TRIPS, we are the member country of WPIO, we are the member country also of GATS. So when we have signed this at the national level, what becomes our obligation? Right? So the government has recognized the importance of intellectual property. They have recognized how it can contribute to the development of the country. So the government itself has brought about a national IPR policy. They want to promote people entering into more innovations and creativity. For that, they brought about a policy. What is that policy? It is the policy. Why do we need that policy? Firstly, is to create a roadmap for IPRs in the country. Until and unless people do not have clarity with respect to intellectual property, what is it, what does it mean, what protection is given, how is the system, what is the procedures, people will not be inclined in getting into that field. So you should have a clear roadmap of how we are going to give protection to intellectual property rights in our country. Exclusive right of intellectual property to safeguard the originality of the inventor's work. So that right, that is, I told you right from the beginning, I am telling you two rights are there. One is you are going to give the you have the exclusive right to use your own products. Nobody else will be permitted, right? So that right, how are we going to give to the inventor and to the creator, and to grant the creator limited time and exclusive permission to utilize his work. Again, it is similar to the concept of IPR. The same thing has been recognized even in the international national policy of IPR. What is the objective of the national IPR policy of the country, that is India? They want to encourage more and more innovation, more the innovation, more products, more the capacity of being increasing the exports of the country, enhancing the business climate, right? What is business? If there are products, if there are services, then business can take place, and that business can come only when products are coming. So indirectly everything is revolving around the encouragement for getting into more innovation, getting into more creativity aspects, bringing more products into existence, right? If you do innovation, products are going to come. If that product is going to come, you can increase the business aspects and make it easier for commercially utilizing the intellectual property. You have created the product, you have developed the product, right? Now, how are you going to exploit it? How are you going to make profits? How are you going to generate the profits out of the product that you have created? That is called as commercial exploitation of your product. How you are able to generate revenues out of your invention. So these are the three things that have been focused on in the policy of how we are going to encourage them, how we are going to help them establish the business, how we are going to help them exploit or commercially make profits and revenues out of the innovation. This is the objective of IPR policy. Next. Focus of IPR policy is on improving access to healthcare and food security, environmental protection, social and technological importance. These are certain areas where exclusive protection or exclusive focus is going to be given on. Fostering creativity and innovation, this is the main thing. From beginning we are seeing whether it is the WPIO or TRIPS, the main thing is we want to tell people, we want to nourish people, we want to help people who are in innovation and creativity. We want to promote entrepreneurship. You find a problem, you give a solution for that. That is called the startup era, right? That is what is entrepreneurship. So you come up with new products. We want to promote new products. We want people to come up and enter into the business segment. If there is business, there is employment. If everybody wants to become an employee, everybody is looking for a job, somebody there should be there for creating that job. So that is promoting entrepreneurship and enhancing socio-economic and cultural development. Like I told you, if there is a product, the company is going to grow socially, economic and culturally, right? So all that is the focus of the national IPR policy of the country. Structure of IPR policy, very important, because we told that if you are a signatory of the international agreement, you have to be compliant with that at the domestic level. So whatever IPR laws we have in the country, also talking about the IPR policy of our country, it is TRIPS compliant. So whatever policies we have in India, they are complying with the provisions of the TRIPS agreement. Provisions to protect IPR. So the policy is created in a way that we are going to give protection to the intellectual property rights. We are going to balance the development objectives by making use of flexibility offered by the global regime. We saw the flexibility that was given in the TRIPS agreement for member states, that you can change the laws to suit the requirements of your country, but ultimately you should be compliant with the TRIPS agreement in whatever way. Those changes are permitted. So how you are going to manage the balance of development and the flexibility option that has been given to you, and special emphasis on spreading knowledge about IPRs, creating as a tool of economic development. Many people don't know what is intellectual property right, they don't know what is patent, trademark, etc. They might actually be in possession of a trademark, a logo that has developed brand name, but they don't know that it can be protected, they don't know that it can be registered, they don't know that they have an exclusive right of using that logo or using that brand name. So we should create more and more awareness about the intellectual property rights, and that is going to help in the economic development. So the structure of the policy is in a way that it is TRIPS compliant. It is going to keep in mind the flexibility that has been given in the TRIPS agreement. It is going to focus on protecting the intellectual property rights, and lastly on creating more awareness about the intellectual property laws. Coming to the 7 goals of the IPR policy, please mark it important. Again, important question from the exam point of view. The national IPR policy has 7 goals. IPR awareness, outreach and promotion. Like we saw even in the structure of the policy, it is about creating more awareness about the intellectual properties and the intellectual property rights, so that the people can actually exploit their own creations and inventions commercially, that they can make money out of it, they can generate revenues and indirectly help in the economic development. Creation of IPRs, again, we want more and more people to get into the innovation and generate IPR, and for that you need generate the intellectual properties. For that we need a lot of innovation and creativity from the citizens of the country. So you should help in generation of intellectual property. Legal and legislative framework, that is left to the IPR laws at the national level. It should be TRIPS compliant, and it should help in having a very good system of registration, procedural requirements, protection. In case of infringement, how are we going to deal with the disputes? For that you should have a very strong legal framework and laws and rules and regulations. Administrative and management, that is to modernize and strengthen service oriented IPR administration. So that is why, how do we manage? Okay, there are journals for publications. How are we going to manage and administer the entire department of intellectual properties in the country? Commercialization of IPR, again, how are we going to exploit, how are we going to make our innovations and creativity commercial in nature? You have developed a product, how are you going to put it in the public domain, how are you going to sell it, how are you going to export it? You have done a creativity, you have made a song, how are you going to commercially exploit it, how are you going to make money out of your intellectual creations, is what we have to focus on. Enforcement and adjudication, at any point of time if there is any kind of dispute, how are we going to enforce the rights that are created, how are we going to administer it? For that you need an entire mechanism that has to be established. And human capital development, that is nothing but how we are going to give training, teaching and research and skill building for IPRs. These are the areas and avenues or the goals that the national IPR policy is aiming to achieve. So that is all about the first chapter on the basics of intellectual property laws, where we have seen the national laws, legal regulations at the national level, we have seen the international perspective, and we have seen basis of what is intellectual properties, kinds and classifications. The questions from the previous question papers of the institute, there is one question from this particular chapter where they say what is meant by an industrial property under intellectual property rights. So this question is from the classification of intellectual property right, where we know that intellectual property right is classified into two. One is copyright and another one is the industrial property. Under the industrial property you have patent, you have trademark, you have designs, right? So that is what they are asking, what is industrial property? So in the introduction you can say that the intellectual property right is classified into predominantly two categories, copyright and industrial property. Then go on to explain what is industrial property and what are the classifications of industrial property. So this is the question from this particular chapter. Let's move ahead to the next chapter. My next focus of area is law relating to geographical indication of goods, lesson number 19 of your syllabus. Now what is geographical indication? What is geography? Nothing but some kind of place, some kind of location. Okay, associate with the maps. Okay, some kind of location, some kind of place. What is indication? Some kind of hint, right? Some kind of direction of goods. So what are we identifying here? We are identifying that there are certain category of goods. those goods are associated with certain kind of place or certain kind of location, right? And we are indicating that these goods are from this particular place. That itself is called as a geographical indication. Certain goods are attributed to certain location. For example, let's say silk. It's associated with Mysore. You have also a sweet called Petha, that is from Agra, right? You have Darjeeling tea, you have Nagpur oranges. So certain places are famous for certain goods, and the name itself is indicating to you that this good is originating from so and so place. That itself is geographical indication. Now, why do we need to protect geographical indications, and what are the laws associated with it? It all comes with the negative ambit about counterfeiting, right? There is a genuine product. A product originates from a city called Nagpur, right? That is originally, that particular product is from Nagpur. Nagpur is famous for that, okay? Now, people might sell a product which does not originate from Nagpur. It is a product that is artificial, it is something that is not original, it is not a genuine, but they are selling in the market saying that this is from Nagpur. So that is wrongfully portraying the product to originate from a particular location. To avoid these kind of activities, it is important for us also to give protection to the genuine products which are actually coming from a particular location. That is why we need to give protection for the geographical indication of goods. Now, let's see what is it and how did it evolve. Again, going back to the history long back, that people when actually were in, generally the man's desires are such that we always want good quality and genuine and premium products. We are always looking for the best. In that search itself, people have moved, okay, countries, sea routes have led to the creation and discovery of newer sea routes and newer continents. That is how people move from one continent to the other continent looking for what is better, what is available here, what is available there. That is how the entire world came into being, world came into recognition. With the same desire and same human need of quality and premium products, we have started identifying that okay, this place is famous for this country is famous for this particular region is famous for this. So that is how the entire concept of geographical indication started being recognized. Okay, these identifications become so important that certain regions started specializing in the producing of unique products, which led to identifying of the goods as originating from that particular region, which over a period of time has become renowned globally. We know that this product is available only here. Now we know that that particular product will genuinely be available in that place, and it is recognized that this product is from this place, this product is from this particular locality. That is how over a period of time certain goods have got recognition from the place where they are originating, and that itself is geographical indication. In rising demand for such genuine quality and premium products, it gave rise for counterfeited products, that is nothing but artificial. Something that is not genuine, but you are passing off in the brand name of a genuine product, began to tarnish the image of the genuine product. So you expect that if we say this is Mysore silk, it should be of certain quality, it should be of certain standard. But some people started selling some other material, calling it as silk from Mysore. So now that quality is not nice, that material is not nice. So what is happening now? People have started thinking that, oh, this is Mysore silk, it is destroying the brand, it is destroying the actual quality of the product that is actually there. So in that case, to avoid these kind of people, we have to give recognition to the genuine products, and that is why we have brought into the concept of GI tag. So any original product will definitely have this GI tag associated on the product, that this is the genuine product. So if you are looking at a product which has a GI registration, GI tag will definitely be there so that people and consumers can identify, okay, this is an original product. If somebody else is trying to sell to you Mysore silk sari and it does not have a GI tag on it, please understand that it is a counterfeited product. So to avoid counterfeiting in the market of GI, we have to give recognition to the geographical indication, and that is why protection is required to be given. An effort to safeguard the interest of the producers, because what is going to cause damage to the producers? Their product is going to lose the reputation, their product's name is going to be hampered, ultimately their sales is going to reduce. So that is going to cause a damage to the producers. To the consumers, they are going to get wrong products, they are going to get artificial products, they are going to get counterfeited products, they are going to be misled by the people who are selling counterfeited products. So in order to protect not only the producers but also to protect the consumers, we have to bring about an evolution and the concept of geographical indications into place, where we are recognizing the importance of a product, the origin of its existence, and then protecting the two. So what is GI? GI is nothing but there is some kind of good. This good is originating from a particular place. We are going to give recognition to the good and the place of origin and identify that product as a GI product and create a GI tag and registration, so that now we know that this is a registered geographical indication, that this good is associated with this place, and the indication is clear that this good is having some kind of unique character, some kind of premium characteristics, some kind of the nature of product is such that it is existent or coming into being only because it is from this particular location. So three things are important in geographical indication. First one, there should be some kind of good. That good or that particular product should be coming from a particular locality, region, or a particular country. And that product that you are talking about should have some kind of unique, premium, or different characteristic which is distinguishing it from the products of any other locality. So if these three things are there, we are going to give protection as a geographical indication. Let's see. So every region has to its claim some kind of fame. Whatever you see, whether you see wine, whether you see cheese, whether you see some kind of leather, whether you see some kind of food commodities, every region will have some kind of speciality to it. So the claim, the fame comes to any particular place or a region from the goods and services that it has in his locality. So each fame and reputation was carefully built up and maintained by the masters of that region, combining the best of nature, the man, and the traditionally handed over from generation to generation from centuries to come. Specifically in India, okay, you have certain traditions. Through those traditions, you have arrived at some kind of product that is exclusively available only in that particular area, and the man has recognized how to do it, and with the help of nature, because most of the products, the temperature, the locality, the environment, the weather, the availability of those raw materials, putting all these things in combination has led to recognition of a particular product from a particular location. And gradually a specific link has been established with the goods and the place of the production evolved, resulting in the growth of indication. So two things are required. There is a requirement of goods and there is a requirement of the place. And with respect to goods, there is an important need that it should be a unique product, it should have some specific feature, it should have some kind of characteristic which distinguishes it from any other product from any other locality. So good plus place will give you geographical indication. Now, meaning of geographical indication. Geographical indication of goods are that aspect of industrial property. Again coming to classification, you have intellectual properties. In that you have copyright, you have intellectual industrial property. Okay, this is intellectual property, this is industrial property. In industrial property we have patent, trademark, GI. So it is one category, subcategory of industrial property, part of intellectual property, which refers to a country or a place which is situated as being the country or place of origin of that particular product. So what is there? Please identify the keywords and write your answers. That there is some kind of place, and this place is leading to the origin of what? Of some kind of product, and this product is identified with this place as its place of origin, and that itself is a geographical indication. The name conveys an assurance about the quality and the distinctiveness, which is essentially attributable to the fact of its origin and defined as geographical locality, region or locality. Same three things that I've been telling you. There should be a place. From that place a product should be originating, and this product ultimately should have some kind of quality, some kind of distinctive element, some kind of uniqueness, some kind of separate characteristic of nature. If all these elements are present, we can classify it as a geographical indication. Regulatory provisions for geographical indications. Again, we have already seen the basis of there is something at the international level, and to comply with the international level, we have the laws at the national level. Because India is a signatory of the TRIPS agreement, we have to first see what is provided under the World Trade Organization's TRIPS agreement. Article 22 to 24 deals with geographical indication, in which they have tried to give a definition for GI, which is very similar to what we have already seen. It says that geographical indication refers to any kind of sign or indication which identifies that a good is originating in a particular territory of a country, region, locality, where a given quality, reputation or other characteristics of the good is essentially attributable to the geographical origin. A particular product has a particular quality only because it is originating from so and so place. So same three things that I have told are important. There is some goods, that good is attributable to some kind of locality, region, country, and those goods have some kind of unique characteristics, nature, quality, feature only because it is originating from that particular location, place or territory. This itself is a geographical indication. Coming to the enactment in India, we have the Geographical Indication of Goods, Registration and Protection Act of 1999. First, we are going to tell them how to register a geographical indication, and then how it is going to be protected, that how people should not misuse the geographical indication, how protection is going to be given to the geographical indications. So why did we pass this enactment? Because India is a member state of the TRIPS agreement. We had to be in compliance with the TRIPS agreement, and that is why when TRIPS agreement included the clause on geographical indication, we also had to become compliant to the TRIPS agreement, and that is why we had to pass this particular enactment of 1999. Coming to the objective of the Act, that is the GI Act 1999. First and foremost, it is to protect the interest of the producers of such goods, because they are the people who from generations or years together have helped in the building of the reputation of that particular product, right? So we should give them the protection that their product is genuine, their product is original, their product is having some set of characteristics, uniqueness, some kind of distinctive element. So the producer should be protected that their goods are not losing their reputation, or what do we say, the quality of the product is not compromised by the passing of goods. What is passing off? Very important, passing off in the terms of intellectual property. Product A is the original product. It belongs to, let's say, brand X. A is the product A, brand is X. They are selling it. Now what is happening? There is one more product which is a product B. It is not brand X, but they are portraying that they are brand X. It is a totally different product. It is not branded by the company X, but still people are trying to sell that product under the name of brand X because they know people are fond of brand X. People are very, very fond of brand X. So seeing that name itself, people are ready to buy the products. So there is one more product which does not belong to brand X, but people are trying to pass it off into the market by portraying that it belongs to brand X, that is passing off goods. So when the goods are passed off in the name of false GI, that leads to some kind of damage to the producers of the original GI products. So it is very important for us to protect the interest of the producers. It is important to exclude unauthorized person from misusing the GI, because we are talking here not about one person. If it is a GI is not given to one particular person, it is for the members who are living in that particular locality, people who are authorized users of that geographical indication. So it is not going to impact one person, but it is going to impact a larger group of people. It is going to impact the producers of that particular GI. So we should prevent the misuse of the genuine geographical indications. Protect the consumers from deception, that is nothing but passing off. We should prevent the consumers from being misled by saying that this is the original product, but actually you're giving them a duplicate product. So that misleading should not be there. That is why we should also protect the consumers. To promote the goods bearing Indian GIs in the export market, very, very important. Indian products have a total different standard. There are so many products which are exclusively available only in our country. So if we are going to give recognition to these products with a GI tag and GI recognition, GI registration, that is going to help in the exports of these products, which is indirectly also going to help the country's economic development. So these are the primary objectives of the GI Act, where they want to protect the producers, they want to protect the consumers from being misled, they want to prevent unauthorized access of the GIs, and they want to increase the exports of the country. This is a main objective of giving recognition to GI. Few examples of Indian GI which has got registration is Darjeeling tea, Kanchipuram silk sarees, Alfonso mango, Nagpur oranges, Kolhapuri chappal, Bikaneri bhujia, Agra petha. Close in India as of now, I think if I am right, we have close to 640 GI tag products, GI registrations of close to 640 products. This is just a small list, right? So these are Indian GI registered products. Now, coming to the definition of GI under the enactment, that is the GI Act of 1999, Section 2E talks about the definition for GI. They say that GI in relation to goods means it is an indication. What is the indication? That this good is originating from so and so location. Okay. It is an indication about the goods, whether the good is an agricultural good, whether it is a natural good, whether it is a manufactured product. Now you saw the list, right? You already saw the list. Darjeeling tea. Tea is a natural, it has come from the plant. Nobody is manufacturing tea. You just put a plant, and from the plant, tea leaves are taken. So it is natural product. It is agricultural in nature. Silk is manufactured. Mango is a natural product, agricultural product. Orange Nagpur or Nagpur oranges is natural. Kolhapuri chappal again is manufactured. Bikaneri bhujia is again brought into existence. Agra peta is also cooked, right? So you have to classify the goods, whether it is coming from agricultural background, whether it is natural goods, whether it is manufactured good. That classification indication is there. Second one, it also talks about origination and manufactured in relation to a particular country, because ultimately when we talk about GI, three things are necessary. One is that there is a good, and that good should originate from a place, and that good should have some kind of distinctive characteristic element or feature. So first one, you are indicating a good, whether it is agricultural good, natural good, manufactured good. Second one, you are indicating that it is originating from a particular locality, and that particular product that you are talking about has some kind of quality, reputation or other characteristic which distinguishes it from the other kind of products, merely because it is attributable to the geographical location from where it is coming into existence. And if the goods are manufactured goods, one of the process of manufacturing is taking place in the locality from where it is originating. Suppose you are talking about Kolhapuri chappals, okay. For making the chappal, you need raw materials. You have identified that this kind of chappal is available in a place called Kolhapur, right? Now, the process of making chappal, one of the process, okay, it is going to have a series of steps. One of the step of manufacturing or production should be in the locality where it is originating from. Even if one step is not carried out, you cannot give the GI tag. So, if it is a original product, national product, agricultural product coming from that location, easily you can say that this is grown here, it is famous for this particular product, easy. But when you're talking about manufactured product, it becomes difficult, right? So that is why they say that one of the step of the manufacturing process should take place in the locality where it is originating. Only then we are going to give the GI tag. Maybe the place is famous for that, but if no process is carried out in that place, still we cannot give the GI tag, because one of the process of manufacturing is not being carried on. So that is one extra condition that should be fulfilled when you're talking about GI tag for manufactured goods. Next, it may be noted that the name which is not the name of a country, region or locality shall also be considered as GI. Now, whatever example we saw, Darjeeling, Nagpur, Kolhapur, Agra, words of the places is there. You have identified a location. But there are many a time or situation that even if the name of the location is not there, we can still go ahead and give it a GI tag. When it relates to a specific geographical area and is used upon a relation to particular good originating from that country, region, as the case may be. So even if it is not the name of a country, it is okay. Merely the name of the locality, region is sufficient to get it a GI tag. Next. So because we are talking about the two things, geographical indication, it is in relation to goods. So two terminologies become important, that is goods and indication. What is goods? Goods can be any nature, like I told you, it can either be agricultural commodity, it can be a natural commodity that is there, right, because of the nature. It can be manufactured or any other category of handicraft, okay, including food stuff that we are going to bring into existence. And indication, it can be anything. It can be geographical, it can be figurative representation, it can be a combination of it, conveying or suggesting a geographical origin. How are you indicating that this particular product is originating from this particular locality? That itself is indication. To sum up, this is very, very important. For any question on GI, you can write this. What is it? First and foremost, is an indication. Indication of what? Indication of goods. Of what category? Agriculture, manufactured, nature or food stuff. Next one, what is it indicating? It is also indicating the place of origination of a geographical territory. It should be related to a specific place, specific region, specific locality or a specific country. It is used to identify the kind of products, that is agriculture, natural, manufactured, I already told. So it indicates two things, the place of origin and the kind of products that are dealing in. In case it is a manufactured good, one of the process, either product or process, should be carried out in the place of that territory. And the most important thing is that particular good which is originating from a particular place should have a special characteristic reputation to call as a GI. So if you want to sum up, what is GI? For GI registration, you need three elements. First one, it should be an indication about a particular place from where the origin is coming, and that origin is of a particular product, and that particular product should have some unique feature, some unique characteristic. If these three things are present, only then you are going to get the GI registration. So this is the basic sum up for what is a geographical indication. Examples of registered geographical indications, again long list is there, you can write anything. This is, I have restricted it to the Indian GIs, but also GIs of other countries can be taken into consideration. You have cheese from a particular place, you have wine from a particular place. Every place is known for something, so you can write even international geographical indications. Now coming to what is the benefit of getting registration for a geographical indication, we saw the objective of the Act of 1999. On the same lines, if you see, you can derive the benefits. First one, it is going to give reputation. Okay. It confers legal protection to GI in India, that if it is a goods that is originating from any place or territory or locality or region of our country, we should give it protection, legal privilege, that only we can sell the goods as original premium quality goods. It prevents unauthorized use of registered GI by others. That is same thing. You cannot mislead the people that this is a product originating from a particular place, but actually it is not originating. It is a duplicate product, or you have falsified claim that it is a GI, right? Provides legal protection to Indian GI, which in turn boosts exports, and it promotes economic prosperity of the producers of the goods which are in relation to that particular geographical territory. So same thing, it is on the same lines of the objectives to, it helps in production, it helps in the boosting of exports, it gives protection to the producers of the goods of that particular locality, it prevents the others from misusing the GI, and it gives protection to the producers who are actually genuinely manufacturing the GI products. Prohibition of certain registrations as a geographical indication. Section 9 of the enactment has certain kind of restrictions. They say that certain geographical indications will not be registered if they come under any one of the following criteria. First one, it is to deceive or cause confusion. Your GI is going to cause confusion for whatever element, it is not going to be permitted. It is contrary to the existing laws. Some kind of product is illegal. For example, drugs are not allowed in India. It is illegal to even be in possession of the drugs, let alone producing the drugs or growing the plants which are going to give you ultimate product of drugs. The product itself is illegal. It is contrary to the law of the country. So you cannot obtain a GI tag for a drug, right? So any product that is any law or any product that is contrary to the existing laws will not be permitted registration. Comprising scandalous or obscene matter, okay, something that is not decent will not be permitted. Likely to hurt the religious susceptibilities. Disentitled to protection in a court of law. The court has law has not recognized. You claim that it is originating from so and so locality, but the court is of the other opinion that you are not able to justify that this product is originating from this particular locality. When the court itself is not recognizing the originating locality, then in that case they cannot obtain the GI. Determined to be generic name, very generic in name or indication of the goods, or have fallen into disuse in the country, right? It was a product from your place, but it has been so generically available, or you have stopped using that particular thing from your locality, then we will not give that recognition. Even today, if it is associated with the locality, even today actually that product is available, even today if actually that GI makes sense that there is a product, it is from a locality, originating from a particular locality and has characteristics associated with that particular locality, only then it will be given. In some time it was there, but currently it is not in use, we will not give the GI tag. And falsely representing the origin of goods. It is not originating from Nagpur, but simply you are putting in the name originating from Nagpur. That is misleading. So falsely, if you are saying that it is originating from so and so locality, it is false, right? For example, Bangalore. From Bangalore, we have no product as such, but simply to show to the consumers that, oh, this is from Bangalore, you are just including the name Bangalore in front of the product. That will not give you a GI. It is falsely you are claiming that it is originating from a particular place or originating from a particular locality. And actually, that is not the place of origin. You are misleading the public. Then that will not be permitted for GI registration. So these are the restrictions. Now let's get into the registrational requirements. Henceforth, we are going to see how to submit the application, what is the procedure, and how we are going to get the certificate that this is a GI product. Section 8 of the GI Act of 1999 talks about the registration aspect. It says that the section 8 talks about registration. Okay, there is a particular class of goods. Within that you have multiple articles. Okay, so it is depending upon, so if there is a bakery items will be one class. In that bakery items you will have buns, you're going to have fried items, you're going to have let's say some kind of drinks, some kind of juices. So that are different articles coming under the bakery item. So you have one class, that is the various range of products. Individual products will come under the list of articles. Same thing applies even for a geographical indication. You have class of goods. Within the class of goods you have various sub articles, sub products that can be a part of that class. So it is allowed for people to get their products registered under a particular class as determined by the registrar. Okay, so list is there, number is there, you can choose and make an application under which class you want your registration. But at any point in time, if you have a confusion about under which class I should get my products GI tagged, the confusion can be solved by the registrar. The registrar can step in and tell you which is the most suitable class for registering your GI product. The registration can be for a specific territory within a country. Again, like I told you, because we are talking about GI registration, the place of origin is very important, and that should be very specifically provided in the application of registration. The registrar is empowered to classify the goods according to the international classification of goods and registration purposes. Like I told you, we have nice classification, NICE, for identifying which is the class, because again when we are talking about international trade, international transaction relating to intellectual properties, the class of protection becomes important. So if we are following one standard class of registration, class 21 in US is same as class 21 in India, then it becomes easier for identification and also international transactions. So they say that in India also for registering GI we follow the international standards. List is there, according to the same list we are following registration procedure in India. The alphabetical index of classified goods is to be published in the prescribed manner. So as and when new GIs are being granted, new registration is granted, in the alphabetical order they should maintain a list of the registered GIs in the country. In case of any dispute in relation to GI, the solving procedure should be done, or the dispute resolution should be done by the registrar, whose decision is going to be final. Again, this we are talking at the national level. If 2-3 people are fighting with respect to GI within the country, then the registrar is the person who is going to do the dispute resolution. But if there is a dispute between 2 or more countries, then the dispute resolution mechanism as per the TRIPS agreement will become applicable. Next, eligible entities, most important. When you are talking about a patent, I have thought about inventing a product, I have put my hard work in bringing that product into existence. I am the one who have thought about a music tune, I am the one who has thought about the lyrics of a song. It is me individually who has worked on. So the protection is going to be in my name. But what about the geographical indication? Lot of people are residing in that locality. So who should be given the recognition as the owner of this particular GI? So who is the person who is eligible to make an application for getting a tag of a geographical indication? So that we say eligible entities. It can be association of persons, because no one person will have a right over the entire geographical territory. A lot of people reside in one territory, all of them have equal rights on the products or the products originating from that particular locality, right? So for that reason, a group of people put together, association of persons put together, can make an application for GI. Producers of that particular product, right? From generation to generation, a particular community might be involved in manufacturing of a particular product. So that particular producers association can come together and make an application. Or organizations authorized or established by or under any law for the time being force for representing the producer's interest. If the producers are farmers, they don't know, all these registration requirements. In that case, the court can authorize any one organization, NGO, not-for-profit organization, Section 8 companies for helping getting this GI tag. So it can either be association of persons, it can be a group of producers, or it can be any organization authorized by the law courts to help get the GI tag. Application must be in writing, submitted to the registrar within the prescribed form along with the necessary fees as may be prescribed. Application content, what should be there in the content of your application? Again, by the nature of requirement, you should know, you should tell what is the product, what class it falls under, what article it falls under, what is the location origin, from where it is originating, and what is the specific and special characteristic of your product, right, and from how long it is in existence. All these are the things that you have to include in the application to make a strong base for actually getting the registration as a GI product. The statement explaining how the geographical indication originated from the origin and what are the special characteristics of your product. Class of goods under which you want your registration. Geographical map location, you should give them the location, actual location on the maps where it is originating from. Details of the geographical indication appearance comprised of words and figures. What is the representation, how you want to treat it, okay, some kind of logos, some small description, how you are going to treat it as a GI. A statement containing particulars of producers who are initially registered with the registration of GI and any other particulars as may be prescribed. So this is what should be there in the application when you are submitting an application to registrar for seeking registration for a product as a GI product. Application can be made for different classes of goods, and for every class you have to pay separate fees. Okay, so now your product is there. The product can fall under 2-3 categories. So under all 3 categories you can seek registration, but for every category of registration you have to pay additional fees. Filing location. Now because it is the registration at the national level, we have multiple registrar offices situated in our country. So where are you going to submit the application? North, south, east, west? In that case, wherever geographical indication registry within the territory of relevant indication. So the south region has been given certain territorial boundary. The north registrar office has been given certain territorial boundary. So where your territory boundary comes, where your territory is situated, where the GI is there, where your place of origin is there, whichever jurisdiction the registrar office has over that particular locality, with that registrar you're required to submit the application. Examination, the registrar is going to see the application, see the contents of the application, see everything is in order, all the information is there. He is going to examine the application. If he finds it is justifiable, he is going to go ahead and grant the recognition. But before that, it is entirely the decision of the registrar. Either he can accept it, he can ask for more information, or he can reject it. These are the 3 options available for him. He can either refuse it, he can accept it fully, or he can accept it with certain conditions. He can make certain modifications or impose certain kind of restrictions or limitations. These are the multiple things that the registrar can do once he receives the application. So in case he refuses the application or he gives conditional acceptance, okay, in that case he should clearly specify the grounds. Why did he refuse the application? Why has he imposed certain conditions? Why has he imposed certain limitations? The reasons for imposing those restrictions or reasons for refusing the grant of GI should be specifically given, along with the reasons why we have not given you the GI recognition. Section 16 talks about registration. 2 outcomes are possible. One is we are going to give you a go ahead that yes, your application is genuine, everything is correct, all the information is available, you are eligible for getting the GI tag. In that case, the registrar is going to go ahead and issue the certificate of registration as a GI product, and that registration will be in the name of the association of persons or the producer. So it is not in the name of one individual person, it is a group of people who will be entitled to sell the product with the GI tag. On the other hand, either your application has been rejected or They've called for more information, but you have not given them the information. For all these reasons, the application can be abandoned. That means we are consider the application as incomplete. You have not given us the required information. You have not complied with or completed the information within 12 months from the date when the application was submitted. We are going to treat that you are not interested. You are not giving us the information. So we are going to stop the process here and we are not going to process it further. So 12 months maximum time is there. If within 12 months you don't give a proper response to the registrar about the information that they are asking for, we are going to treat your application as abandoned and stop the procedure of registration, right? This is the registration process. Now, coming to the stepwise procedure, first one is submission of the application. You already know what is the content of the application. That application is required to be submitted to the registrar in triplicate, means 3 copies of the same application is required to be submitted, and it should be signed by the applicant. Because here applicant is not an individual person, it is either a group of people or association of persons. Who is the signatory or who is the agent? Okay, one person can be authorized to be the authorized signatory. That person can sign the application. 3 certified copies of the map of region should be submitted. So we have map of India, you have map of the state, right? According to that certified map, because the territories are important. So with that certified copy of map, 3 copies of map is required to be submitted, and including the details of what are the special characteristic, inspection structure and applicant details. All these things are required to be submitted at the first stage. Second step is preliminary scrutiny and examination. The registrar is going to receive your application, is going to see through the contents of your application and identify if some kind of deficiency is there, some information is missing, some document is not being attached. For that, they are going to do the basic scrutiny check. If they think that something is not there, they are going to call for that additional information, and it becomes the responsibility of the applicant to submit that information. Once they have got all the information, they are going to go ahead and examine the application with the full-fledged complete information. After doing the examination, they are going to reach to a decision whether we are going to give it or not give it. Right, so applicant remedies deficiency within 1 month. 1 month's time is given for them to give an answer to the department. Consultative group of experts assess statement of case, examination report is issued, whether it is eligible, not eligible, what is their opinion about the GI product. Next is show cause notice. In case the registrar himself has some kind of objections, he has some kind of doubts with respect to anything in relation to the product and the place of origin, he can call for objections and ask an explanation from the applicant of whatever doubts he may have. And the hearing can be done within 2 months. The decision communicated with the option to appeal. Registrar can withdraw the application if accepted in error after giving an opportunity of being heard. He's sent an objection, but later if he is satisfied, he can withdraw the objection application. If somebody is not happy, they can also have a right to appeal. Publication in the GI journal. So again, we are going to accepted applications will be published within 3 months in the journal. Any person who has a objection that no, this is not a GI product of this particular, this is not the place of origin, our place is the place of origin, how is he claiming? So we are going to put it out in the public for seeking public objections. First we are seeing the objections of the registrar. Only if the registrar is satisfied, he is going to go to the next step. Next step is seeking the clearance from the public at large. So we are going to publish in the journal. In the journal it is published, and any person who has any problem, if GI is given according to the application, he can make an application, no, this is false, this is not correct, our locality is the locality which is producing these products, he can raise an objection. So any person can file an opposition within 3 months. It can be further extended as per the request and a requirement. The copy of counter statement must also be submitted to the applicant within 2 months after the notice has been given by the registrar. Next is opposition to registration. If the applicant does not do this, then it shall be deemed to have abandoned the application. So then obviously, if you are not replying back, if you are not getting the queries, if you are not solving the queries, if you are not replying back to the opposition filed by the public, from members from the public, in any case you are not giving an answer to the registrar, they are going to treat your application as abandoned and stop the process of registration, because you yourself are not interested. Now the ball is in your court to give an answer to the registrar. If you are not giving the answer, we are going to treat that you are not interested, we have abandoned the application, and no more registration procedure is going to be carried out. All the evidence is going to be submitted by the way of affidavits and supporting documents. Hearing is going to be scheduled. Registrar is going to hear the parties before making the final decision. Then is registration. If he thinks that everything is proper, there is no opposition, okay, there is no objection, nothing is there, everything is proper. Even if there is an objection, the applicant has given a proper answer to that and he is given a justification, they can go ahead and give a registration to that particular product. The date of filing will be the date of registration. The date of filing of the application will be considered as the date of registration of the GI, and a certificate is going to be issued, and the GI indication registry, in that entry will be made and the certificate will be issued that this group of people or association of persons have the GI tag. Renewal, again the period of registration is initially only for 10 years. After 10 years again you have to make an application for renewing your GI. That is payment. You should make a payment and say that still we are continuing with the production or manufacturing of the GI products. You will get the renewal. Protection for notified goods. Certain goods are there, sensitive goods or which are actually very extinct, very rare. So, certain kinds of goods might be given extra privilege. For that, additional laws or rules and requirements might there, that has to be followed. And appeal. If at any point in time you are not happy with the decision of the registrar, he is not giving you the registration, you are aggrieved by his objection, you are aggrieved by the objections, you are aggrieved by the rejection that he is given, you have a right to appeal and you can take the registration requirement or the application to the next level. So, this is the entire procedure of registration, very basic. You file an application, they are going to do the basic examination. This is the first route, okay, first route I am talking. They do the examination. In examination, they find that everything is perfect, no objections, no queries. They are going to accept the application. Once they accept the application, they are going to put it out in the GI journal for public inspection. From public inspection also, nobody has raised any objection. Then they are going to enter it in the GI register and issue the certificate of registration. This is first scenario where there is no objection in any stage. No objection from registrar, no objection from the public. Everything is smooth. Right at one go, you are going to get your registration. Second step is where you have made an application, it has gone to examination, the registrar himself has raised an objection that no, something is not right, application is incomplete. Okay, in that case, opportunity of being heard will be given. You give a clarification to the objection that has been raised by the registrar and the department. In case you are able to give it, then they are going to go to the next step, that is called as acceptance. If you are able to justify the objections that they are raised, they are going to accept your application. In case they are not happy with the answers, if they are not happy with the justification that you are giving for the objection, right here the end process will come. They are rejecting your application. It is not even going to go further. Here only your application is rejected. Now, you have got an objection, you have given a justifiable answer. The application is going to be accepted. Once the application is accepted, it is going to be published in the journal for public inspection, for public objection. If there is any opposition from the public, you are required to give an answer. Okay, and if you are going to give an answer and that is satisfied, your application is going to be allowed and it is going to be published in the registry of this thing, and certificate of GI tag is going to be given to you. In case public opposition is there and you are not able to justify the person who has raised an objection, his stand, his case is strong, then your application is going to be refused, again dead end. If you want, you can prefer an appeal because you are aggrieved by the decision of the registrar because he is refused to give you the certificate of registration, right. So, these are the multiple stages that can take place, multiple routes or scenarios that can happen when a GI registration is filed for. Now, coming to the duration of registration, same. Initially, you are going to get it for 10 years period, thereafter it can be renewed as and when required. This is registration for GI. Now, GI has got a registration, but who is the authorized user is one more person. Who has the permission for manufacturing or selling the goods with GI tag. Okay. So, for the user is also required to take the registration. It is 10 years, or if let us assume in 2008 the GI recognition was given, but the user started using that particular product, let's say in 2015. Okay, so this has only 10 years. You have started in 2015. This is going to expire in 2018, 10 years. So you can use only till 2018, not for 10 years, but till the expiry of GI. So it is 10 years or till the expiry of GI. If it is renewed further, it can further be also renewed for the user as well. So first you should see whether GI registration is there for a product. After the product, you should see whether the person is authorized to use or not. Okay, that is two kind of registration. Next one is renewal. After every 10 years, you have to apply for a renewal of your application. Next, infringement. What is infringement? Violation. I am the authorized user for the GI products, but Mr. X is selling the products. That is infringement. I am given the protection. My association, I am a producer of goods, my producers association has been given the protection, but somebody else is selling the product, somebody else is depicting that their products are GI products. That is called as infringement, violation of rights. Somebody has been given the right, but somebody else is using it. That is infringement. Okay, so first we are talking two kinds of infringements are there: infringement of unregistered geographical indication and infringement of registered geographical indication. Now where does the actual law comes into picture? The law comes into picture only when a GI is registered. If the GI is not registered, nobody has an exclusive right. So where is the question of infringement? The law will not protect an unregistered geographical indication. Only the GI, if it is registered, you can claim your right. So when we talk about infringement of an unregistered geographical indication, there is no protocol, there is no protection, because there is no registration, there is no right. The same thing is there, and no person will be entitled to file a case or a proceeding for infringement of an unregistered geographical indication. Only if it is registered, a case can be filed. Coming about infringement of a registered geographical indication under section 22, very important. There are three ways in which infringement of a GI can be done. First one is unauthorized use. You are not an authorized user, you do not have the permission. Like we saw, who are the eligible entities for making a GI? It can be either the association of persons coming together, it can be producers association, or an organization in the interest of the producers can make an application. So you have a list of authorized users of the GI. Who can make use of GI? That also one list is there called as authorized users. If your name is not there in the authorized user, you are using it beyond the recognition. You are not the person who is entitled to use the GI tag. That is unauthorized use, right? Unfair competition. When the use of GI results in unfair competition, where you are passing off the goods, right? I told you already the meaning of passing off. So if you are passing off the goods in the name of GI, but it is not a GI product, that is unfair competition. And false representation, same thing. It is not originating from that territory, but falsely you are claiming that it is from this territory, misleading the consumers. These are the three kinds of infringements that are done with respect to a registered geographical indication. In this point, second point, we have spoken about unfair competition. So what is unfair competition? They have given a brief explanation. Whenever you are going to create a confusion with respect to the competitor and the product of the competitors, you are creating a confusion in the mind of the consumers about the product of the competitors. That is unfair competition. You are discrediting the competitor's product. You are misleading the consumers about the characteristics, process of manufacturing, suitability, quality, quantity, nature of the product in relation to GI products. All this leads to unfair competition, where you are trying to reduce the reputation of the competitor's product in relation to the GI tag that they have. Next comes to assignment and transmission. Assignment is nothing but I have a product, I am giving the right to third party to make an use of it. Transmission is that the person who is the holder of the GI tag, that particular community, that is brought to an end. Transmission, how we are going to give somebody else the right to use that particular GI. So yes, in this, because GI as a whole does not belong to one person, I told you it belongs to a particular community. That is why there is a complete prohibition on assignment and transmission. If it is an individual property, you can make an assignment. From individual point of view, you can give the right. If you have a right, you can share it. You can give it to your legal representatives. You can gift it. But it is not yours individually. It is of a group of people. It is of a particular locality, if it is a particular region, right? In that case, because it belongs to a group of people and a larger group of people, we will not permit assignment and transmission of any kind of GI. Any right registered to a registered GI shall not be subject matter of assignment, transmission, licensing, pledge, mortgage or any other agreement. This is only one exclusive kind of intellectual property where assignment and transmission is not permitted because it is related to a group of people. Whether it is patent, whether it is copyright, whether it is your trademark, assignment, transmission, pledging, everything is permitted. Only for GI it is not permitted because it is in relation to a group of people. On the death of the authorized user, his right in the registered GI shall devolve upon his successors in title under the law for the time being in force. Again, it cannot happen because a group authorized user means a long group of people will be there, long list will be there. All of them are permitted to use so. If my name is there in the authorized users list, only I and my community members know. After me, my legal representatives' names can also be included in the authorized users list. So that is what they are saying. The assignment is not permitted, transmission is not permitted, but with communities change, if somebody dies, the other community member's name can be added for the authorized users. Next, prohibition of registration of geographical indication as a trademark. So they are combining two topics, trademark and GI. If a product has a GI tag, can it obtain a trademark? The answer is absolutely no. If you are a GI product, it cannot have a trademark. Okay, that is what they are saying. It empowers the registrar of trademark to suo motu or at the request of any interested party refuse or invalidate the registration of a trademark when the trademark contains or consists of a GI. Because it is already registered as a GI, there cannot be a trademark in the name of any one person, not permitted. If the goods or class of goods which the trademark is registered do not originate from the territory indicated by the GI, or if the use of the GI in the trademark confuses or misleads the consumers, on all these three grounds, we can reject the application for trademark registration. For this comes a very, very important topic. Again, important from the exam point of view, about what is the difference between GI and trademark. What is the difference? Again, GI is a brand, right? You know, Mysore Silk is a brand, right? So if you know that that is a brand, why cannot we obtain a trademark for Mysore Silk? So what is the difference between GI and trademark is what you have to identify. So what is GI? What is GI? It is nothing but a product which is indicated to be originating from a particular locality, and that product has some kind of a specific characteristic. Okay, it is in relation to one product and one locality. One particular place is the place of origin of that particular product having unique characteristics. But trademark is not like that. Trademark is an indication. It is a design, it is a logo, but that can be applied to multiple product 1, product 2, product 3, product 4, right? Adidas, it has shoes, it has t-shirts, it has bags, right? One brand is there, but that brand has multiple products, right? But here we are focusing on one product, and that one product has one location of origin, right? So here you can have one trademark. In that trade name, in that one logo, you can have multiple different skills, different products, SKUs you can have, right? So let's see, it is a sign which is used in the course of trade which distinguishes the goods from the other goods and services. It is going to help identify what are your products and what are the products of your competitors. Just by seeing the mark, you know, oh, this belongs to this particular brand. So that differentiating factor is created. But in GI, we are not creating a differentiating factor. We are giving them an indication that yes, this is having a special characteristic merely because it is originating from a particular locality. Coming to the difference on the basis of the definition, here the particular mark or the sign or identification is used as a differentiating factor factor for differentiating the goods of one company to the other company, of your company to your competitor's product. That is brand name, creating a logo for yourself, creating a brand image for yourself is a trademark. Whereas in GI, we are going to create a GI for identifying that it belongs of a particular quality originating from a particular geographical location. Here there is no competition, nothing. We are not looking at that. We are talking about giving special treatment to certain special products arising from a special locality, specific region. Okay, here it is about creating a differentiating factor. Here it is about giving the recognition as a separate element or a separate unique product. Coming to the purpose of trademark again is like similar lines, distinguishing the goods of your company from that of your competitors' products. But here in GI, we want to highlight the special characteristics of the products which have a specific geographical origin. Scope, again this trademark can be applied for multiple products, like I already told you. For multiple products, same trademark, same logo, same brand image can be used. But that is not the case for GI. If you have a GI, that is applicable only for one product. In Mysore, you have Mysore silk, you have Mysore sandalwood, you have Mysore pak, you have multiple other, you have flowers, Mysore mallige. So all these are related to the city Mysore, but each one of them will have a different tag because it is falling under a different article. So GI is in relation to one product. One GI tag can be used and associated with only one product, whereas if you have a trademark, the trademark can be used for various articles of the same business. It is permitted. Next, application. Trademark. It is applied to a variety of goods and services under the same branded identity, same thing that I told. Here it is only in relation to one specific product and it is attributable to characteristic of one specific product itself. So applied only to one product, applied to multiple products. So that is the difference between GI and a trademark, very, very important. Now the same thing has been decided in one important case, T-Board India versus ITC Limited. T-Board is an organization which is a collective group of people who are into the producing and manufacturing of tea, okay, tea leaves, tea products. So that it is an association of producers, okay, association. They have filed a case against ITC Limited, which is a hotel, okay. So what is the case? Here they say that this ITC Limited had a, what do we say, place, hotel in the name of Darjeeling Lounge. Okay, ITC Limited had one of its place where they used Darjeeling Lounge as the place for coming and having the food or whatever location. The T-Board people have filed a case against ITC Limited that they cannot use the name Darjeeling Lounge because Darjeeling tea has a geographical indication. Darjeeling tea is a geographical indication, it has a GI tag, Darjeeling tea. So they say that if you are putting Darjeeling Lounge in the name by the hotel, it is violating our GI tag that we have. So ultimately the case was held and it was held that court's observation was that it is totally different. Darjeeling has now become a very generically available name and they are not using Darjeeling tea as such, they are just using it as a place, Darjeeling Lounge, where you can come and have food, not necessarily only Darjeeling tea, but you will also have other drinks and other things to eat, right? So it is not violating the GI tag. So the court's observation is that there is no passing off here. The word Darjeeling cannot be exclusively claimed only by that tea association. Darjeeling might also have other important things. Merely because Darjeeling tea is famous as a registered GI, you cannot prohibit the use of the word Darjeeling itself. They are not anywhere claiming Darjeeling tea, they are claiming Darjeeling Lounge, a place where you can come and have your snacks, right? So it cannot be exclusively claimed by the tea house. So they permitted that here there is no passing off, there is no exclusivity that has been given to the T-Board. So there is nothing wrong in ITC Limited from using the word Darjeeling Lounge in the name of any their restaurants or sit outs or a place where they have access to the public. Next, applying the geographical indications. How do we apply GI? So you know that your product is GI product, right? Now how are you going to convey to the people? How are you going to come across apply the GI tag to your products. When do we say that we have applied a GI tag to a product? First one, directly applied the goods themselves. On the goods itself, we have a printing mechanism where GI tag number or a particular logo is there. You can give whatever you want, that will be published, directly applied to the goods. Applied to the packaging of the goods associated with the sale trade of the manufactured goods if it is not original. Okay, in that case, even on the packaging you are putting the GI tag, but inside some other goods are there, even then we say that you have applied the GI. Placed, enclosed, annexed on any package or other things to which the GI has been attached. GI is used in a manner likely to suggest that the goods are associated with it, and the goods use GI in commercial documents, and the goods are delivered to a person on the request or the order made by reference to the GI. You have got that order only because it is a GI product, right? In that case, all the documents, commercial documents, everywhere it should be mentioned that it is a GI product. So where any one of these things are there, we say that you have applied the GI to the goods. So whether it is directly on the product, whether it is on the packaging, whether it is anything in relation to that particular goods, whether you are trying to communicate that it is a GI product, any manner where you are suggesting that the goods are GI product, or on any documentation it has been written that it is a GI product, in all these cases we will say that the user has applied the GI tag or has applied the GI to its products. And only authorized users are permitted to apply the GI. If you have done any one of these and you are an unauthorized user, then a penalty can be imposed for infringement of the rights. Now, applying the geographical indications, it is deemed to have been applied. So how are you going to put it? We said that it can be applied directly on the goods, it can be applied on packaging material, it can be published on the documents. So how are you going to do it? Either you can weave it, impress it, work on it, annex it, or affix it. There are various ways in which embossing can be done. It can be done through weaving. So the different ways are there to communicate that it is a GI tag or GI product. So in any one of these ways, you can put a impression on the product that it is a GI product. Now, falsifying and falsely applying geographical indications. We already see how do we apply the GI directly on the product, on the packaging material, suggesting on the documentation. All this is application. Now, you have done this, but you have done it falsely or falsifying. Then in that case, it is an offense under the Act. And let's see, there are two elements here. One is falsification of GI and other one is false application of GI. There is a difference between the two. When we talk about falsification of GI, that means actually GI is there, but you are falsely projecting to be the user of GI. Here, you are using the GI without the permission or accept or authority of the authorized user. You are not having the right to use the GI tag, but still on your products you are saying that it is a GI product, then that is falsification of GI. A genuine GI is altered, added to, or otherwise tampered with. Then we call it as falsification of GI. You do not have an authorized permission to sell your products as a GI product, but you are still using the GI tag on your products. Then we say that it is falsification of GI. You do not have the authority to use that mark, but still you are using it. Then there is falsification. False application of GI. What is this? Here, the product itself is not a GI product. It is some other product. You are misleading the consumers, deceptively similar, a fake product you are selling in the name of GI. This is fake products. This is counterfeited products. This is artificial products. In the name of GI, you are selling these products. That is false application of GI. Here the products may be genuine. You have only tampered with it, little alteration you have done. But here major issue is you do not have the permission. You do not have the right to sell it. That is falsification. Here falsely applying GI. The products are not worthy of GI. It is not a GI product. Fake products are being sold in the name of GI, then it becomes false application of GI. So, two kinds of offences are there. One is falsification of GI, one is false application of GI. Both of them are not permitted. For both of them, punishment and offence, penalty, imprisonment is provided for. Let's see. Any geographical indication which is falsified or falsely applied will lead to false geographical indication, for which the burden of proving will be upon the accused. The person who has been accused of doing the falsification or falsely applying the GI, he should prove it that he is not at fault. It is burden is upon him, that he should prove that I did not do anything wrong. Now, penalty for applying false geographical indication. So, any person who is falsified, means falsely applying GI, who is altering or falsely applying GI. So, first kind of offense, second kind of offense. Anybody who is in possession of an instrument for falsification, we know we have to apply it. For that, weaving should be there, or impression or embossment. For putting the GI on the product, if you have any instrument and you are having that possession without the permission of any of those instruments which actually apply the GI on the products, if you are in possession of that without authorized use, then there is penalty. Or false indication of origin. Your product does not originate only from that product, but simply for the sake of it, for the sake of passing off the goods as a GI, you are saying that this is originating from so and so place, but in actual that is not the place of origin. In that case also it is falsely applying. Tampering with the indications of origin, you are modifying, you are falsely telling. So, all these things lead to an offense, and if you are doing any one of these activities, you are punishable. But again, you should prove that you are doing, if you are proving that you did not have any intention to defraud, then okay, maybe exemption will be given. But if it is proved that you have done with the intention, you have done it with the intention of defrauding the consumers, you have done it with the intention of reducing the reputation of the producers, then punishment will be given. Imprisonment of minimum 6 months, but which can be extended to a period of 3 years. And a fine which shall be at least 50,000 rupees, but can extend to 2 lakh rupees. Minimum and maximum both they have given. Within this range, depending upon the severity of the offence, they are going to impose the penalty. But at any point in time, if the case is not very serious, okay, it has not caused a lot of damage, then punishment less than 6 months and fine of less than 50,000 can be imposed in rare cases. Okay, it can be given if there is adequate reason, special grounds are there. Less than 6 months and less than 50,000 can also be given if it is a very, very petty matter, if it is not very serious in nature. So, that is all about the entire enactment on GI. Let's look at certain questions that have been asked in the question paper from the chapter on geographical indications. Section 9 of the GI Act prohibits registration of certain geographical indications. Yes, we already saw something that is obscene in nature, scandalous in nature, hurts the religious susceptibilities. Okay, long list is there which is contrary to the provisions of law. We have already covered. Direct question you can answer. Explain the provisions section 39 of GI Act relating to penalty for false geographical indication. We have just seen the penalty provisions for falsification and falsely applying. Minimum 6 months up to 3 years of imprisonment, minimum 50,000 fine up to 2 lakh rupees of fine. It can be reduced below 6 months and 50,000 in rare cases, special situations. So, that is the penalty. Direct question. Geographical indications are special kinds of trademark. Analyze the correctness of the statement by highlighting what is the difference between GI and a trademark. Again, we have already directly covered. It is a direct question on difference between GI and trademark. Yes, geographical indication is also a kind of mark. It is an indication that this product is originating from so and so place. Yes, it is a trademark, but it is a different category because there is a difference, and mention that difference. Okay, give a analysis of the statement. Yes, the statement is correct. GI is also a category of trademark, but it is different from a trademark for various reasons, and that is why we have a separate enactment for GI itself. Next, a case study type of question of the institute. This entire case study is based on that case, the Tea Board Association versus the ITC Limited. Same facts are given. On the basis of that, they have asked us 5 questions. First one, whether ITC is passing off its Darjeeling lounge in the name of Darjeeling tea, whether it is correct or not, explain. How geographical indication is different from trademark, again direct differentiate question. Can Tea Board of India file a complaint against X for selling tea varieties at railway station under the name of Darjeeling tea stall, whether it is correct or not. Whether if the ITC Limited has been operating and using Darjeeling lounge long before the enactment of the Act, what is the punishment for applying false geographical indication. So again, here the differential factor is a direct question, punishment is a direct question. Okay, all others are applicability. So 3 question of case study application is there, which you can answer. It is a direct case study created from the case which is being given in the material itself. So very easy to answer. So that is all about the GI. Let's get into the next enactment, next chapter, that is lesson number 20, talking about laws relating to designs. Now what is design? What is a design? Design is something that you can see through the eye, something visual in nature. I have a pen. The work of a pen is to write. Either it is having a blue ink, red ink, what, does not matter. But ultimately, what is the function of the pen? To put something on paper, to write something. If that function is fulfilled, it is called as a pen. But a pen can be of different design, right? Every pen is going to have, something will have back pin drop, somebody is going to have a cap, somebody is going to have a cap with the gold engraving, okay? Somebody will have something else. So one pen can have different structure, can have different designs. That itself is called as design. Here what we are focusing on is 2 things. One is the function, other one is visual appearance. The function is not protectable. We are not going to protect the function because that is there. Everybody knows if there is a pen, it is to write. If there is a cup, it is to drink tea, milk, water, whatever. If there is, let's say, a car, it is for driving. All of us know that function is already there. You have not created it. What we have created or what we have thought about, the creativity element comes from visual appearance. So under designs, what are we going to focus on? We are going to focus on the visual appearance. We are going to give preference to the visual appearance. If there is something very unique, something creative in the appearance of a particular product, we are going to give it a registration of design. If there is no unique visual appearance, it is merely satisfying the functional element, we are not going to give you the registration as a design. So for protecting, getting protection as a design, what is most important is visual appeal. Your appearance, how does your product look to the eyes? If we see, oh, this is something new, something very unique, it is just a cup of tea, just a cup in which you drink tea, right? That can be basic, just normal, and that also can be manufactured in a way that you have that wow factor. Oh, this cup is so beautiful, right? So that element, that distinguishing factor, that thing that appeals to your eye is the element of design, is the element of creativity, which is going to get protection under the Designs Act. So this is the law relating to design. Let's get into the basics and see what is it. Industrial design, we call it as. Design is one of the characteristics of intellectual properties where design focuses on the aesthetic features of an article derived from the visual appearance. How is it to see? How amazing is the product? How beautiful is the product? Okay, how unique is the product is what we are going to see. It focuses on the appearance, on the shape, on the configuration, on the pattern or ornamentation of the product. These are the things that we are going to focus on. It plays a significant role in differentiating a product in brand recognition and consumer preference. Right? If you have a registered design, you have protection. This is all the advantages that you can have by having a registered design. Now, evolution of law relating to design, again not important from exam point of view because they are not going to ask historical background, because institute has reached a level where we are going to more focus on applicability of the provisions of law. More than direct question, case study type of questions are going to be given. So in that case, evolution and history is not a probable question that can be asked, but just I've created a roadmap of how we came to the Designs Act of 2000. Earlier, Designs Act and Patent Act were clubbed together. Patents and designs were governed under the same enactment. Okay, that is how it came. In 1970, the Patent Act of 1970 was brought into force, where from the Patents and Designs Act 1911, okay, in this act, patents and designs both were governed under the same enactment. Later in the year 1970, the Patents Act exclusively was brought into force. So the patent aspect from the 1911 Act was deleted, but still the designs continued to be regulated under the Act of 1911. Only when India became a signatory to the WTO and the TRIPS agreement, that is when exclusively for protection of designs we needed a separate enactment. That is why in the year 2000 we passed the Designs Act of 2000. This basics, if you know, it is more than sufficient. Now coming to the objectives of the Designs Act, again mostly it is protecting the creativity and innovation. So it is to protect newly created and original designs. Very, very important. Here what? The design should be original, it should be new, something that has not been seen before at all. Okay, that to ensure that the creators of the aesthetically pleasing designs are not unfairly denied of recognition and rewards when others use their designs. You have created the design, you have thought about it, oh, my product should look like this. It is your thought process, nobody else should be permitted to use your design. So we should, the main objective of the act is to not let the creators' product be utilized by anybody else. Next. Purpose of Design Act for effective protection of registration of design, to encourage more activity in the avenue of designing products and to promote design element in the article of production. So the more visually appealing it is, more good for the consumers, right? They will have the inclination of buying the product which is good looking. So in that case, they want to encourage more and more people to be engaged in the activity of designing products. They want to give protection to the design that has been created, and they want to promote the applicability of the design to the products. Now coming to the definition of a design, it is a long definition that has been provided under section 2D of the Designs Act of 2000. I have simplified the definition for you all. Just by reading this, you will understand what is the design. First one is the element. How does it appear? Okay, so it can either be a feature, it can be a configuration, pattern, ornament, composition of various lines, composition of various colors, or a combination of all of the above put together. Anything. It can be, the design could be with respect to the colors, it could be with respect to the features, it could be with respect to the patterns, anything. Okay, anything can constitute a design. It can be applied to any article. So that should be applied to a product, only then you can call it as a design. You can design a product. If there is no product, there is no design, right? So there should be a presence of an article or a commodity or a product. On that product, you should have applied the feature or a pattern or an ornament or a color combination in the form of design, which can either be two-dimensional, three-dimensional, or both. 2D images, 3D images, we say. It can either be two-dimensional or three-dimensional or combination. The design is required to be used on an article through an industrial process, either manual, mechanical, or chemical. Just designing one product is not giving you the right for protection. You are creating that design because you want to manufacture that product in bulk and put it out in the public domain. So the design is going to put on the article by a industrial process. Industrial process is involved in putting that design on the product. That industrial process either can be manual, mechanical, or chemical. By hand also you can put a design on a product, right? So that is permitted. Mechanical, chemical, anything is permitted. And the design should appear in the finalized article, and it should be appeal for sole judgment of the eyes. Whatever you have done, ornamentation, color combination, 2D image, 3D image, manual process, mechanical process, chemical process, all of this ultimately should reflect in your final product. When your eye sees it, you should know that, oh, this has been done to this product. It is not a regular product. It is not only satisfying the functional element, but it is also satisfying the visual appearance. That is what is called as design, but it does not include a few category of things. What does it not include? It does not include a trademark, property mark, or artistic work. Trademark because it is protected under Trademark Act, property mark again under patent. artistic work under Copyright Act. So this is having separate enactment, so it is going to be protected there. So design does not mean trademark, does not mean artistic work or property mark, and any mode or principle or construction which is merely a mechanical device. Very, very important. Any design which by any mode or principle or construction, anything which is a mere substance or a mere mechanical device will not be eligible for being registered as a design. So what is the definition for the term design? It is given what it includes and what it does not include. It can be a combination of one of these features, characteristics, ornamentation, color combination, patterns, okay, a combination of all of these put together which is applied to a particular product. That product can be a 2D product or a 3D product that has to be applied through a process, either manual process or mechanical process or a mechanical process, and ultimately whatever you have done in the previous step, that should be visibly applicable on the final product. Then we call it as a design, but it does not include copyright, artistic work, property mark or a trademark, and something that is mere mechanical device is also not going to become applicable. So on this you are not going to get a registration as a design. Now coming to the next question, what cannot be registered as a design? Section 2 subsection D itself talks about it under the exclusion. Section 2 subsection D itself gives the definition for design itself. In that clearly they have excluded 4 characteristics. One is a mere mechanical device is not allowed to be registered as a design. Something that is artistic work will be registered under the Copyright Act, so it does not come under the registration for designs. A property mark and a trademark. So these 4 categories are prohibited from being registered as a design under the Designs Act of 2000. Now, what is protected as a design? So when you're seeking a registration as a design, what is the protection that you're going to get? You are going to get protection for the artistic element and not the functional element, right? In the beginning, I told you there are 2 important things that you should keep in mind when you're talking about design. There is one, a functional element, and one what we call it as the visual element. It is the visual element which is going to be protected as a design. The functional element will not get any kind of protection even if your product is registered as a design, because that is mere the function of the product. Without the functionality, there will be no product. You're using a product because it is functioning, right? You want to write, that is why you use a pen. That is the functional element. You're using the pen only because you want to write, right? That is the functional element that will not be protected. But people will buy which pen? Lakhs of pens are there in the market. Many brands are there. In one brand also many pens are there. People choose which pen they want to buy on the basis of appeal. How it looks, how fat it is, how thin it is. What is the convenience of using it? What is the design? That is what they see and design which pen I want to buy, right? So that is the visual appearance that makes people buy the product. So we are going to protect the visual element and not the functional element. So what is protected under the Designs Act as a design? Deals with only aesthetic or original design of an industrial product. It usually contains the element of both art and craft, and that is to say artistic as well as functional elements. Okay, a product is going to have 2 elements. One is functional element, one is the visual element. Functional, it has to satisfy, only then people will buy it. If a particular product is of no use, why will people buy it? Right? You want to use it, that is why you're going to the market and buying a product. If there is no functional use of a product, people are not going to buy it. People are going to buy the product in addition to functionality on the basis of appearance. Right? 2 elements are there, functional and visual. Any product is going to have both visual and functional element. Functional element is not protected, but the visual element is protected under the Designs Act. Now, very important, the design law focuses on protecting the aesthetic aspects of an article, but it does not cover the functional features. It grants protection to designs that have visual appeal rather than that serves only the functional purpose. I have already given an explanation to this, very, very important, and this is the factor, very important also from exam point of view, because they can ask about what is the protection that is given under the Design Act. Right? They may also ask whether the functional element is protectable or not protected. So that is very, very important concept from exam point of view. To simplify the same concept, let's assume a teacup. Okay, this is a basic teacup that is available everywhere. What? It should be hollow so that it can accommodate some kind of liquid. whether it is your milk, your tea, or coffee, or juice, whatever liquid element, if it has to hold, it should be hollow, right? If it is flat, it is going to fall off. The liquid will not stay. So for holding a liquid element, you need a hollow. Okay, this is the purpose of a thing, and you should have a handle if it is hot so that you can hold it properly and drink. This is the functional element of a teacup. What? It should be hollow, plus it should have a handle so that people can hold it and drink if it is hot. This is the functional element, having the space to accommodate a liquid and having a handle to hold it in case it is hot. This is the functional element. This cup cannot get a registration as a design, but this cup, it is in a shape of a face. Some different element or designing is done to portray that it is a face. Here also it is given a shape of a rose, given a shape of a plant come combination of some flower. It is different to see, right? It is also having the same function. It is also going to accommodate something to drink. It also has a handle. But seeing this and seeing this, what are you going to buy? You're going to buy something that is visually appearing, something that is different, right? Everybody wants the differentiating factor. So what we are protecting here is not the functional element. If you say that my design has a hollow inch of 5 inches, no, that is not protectable. What is protectable is how we have crafted it. What is the art? What is the color? What is the feature? That is what is going to be protected. So let's see. The design of a teacup must have a hollow receptacle for holding the tea and handle to hold the cup. These are functional features, and the functional features cannot be registered, but a fancy shape, ornamental design on it will be registrable. So you can get a registration that nobody else is permitted to design a teacup like a shape of a flower that I have done. Nobody else can do it because I am the one who have designed it. You can seek registration for this design of the cup, but teacup itself is not registrable. Same thing goes for a table. A regular table is like that. What is required? What is the need for a table? To keep commodities, to keep your books, to keep your flower vase, to keep your mobile phones. So it should be flat. Only then you can keep the things on it. If it is curved, as soon as you keep something, it is going to fall. So what is the function of a table? To hold things on it, to keep things on it. That is why it has to be flat. So you cannot say that my table is flat, please register it. No, that is the functional element of the table. It has to be flat. If it is not flat, you cannot keep anything on the table. So it is not a registrable. But how you design the table? See here. How is the stand for the table? What is the stand for the table, or what shape they have given to the table? That is what is registrable. The design, how visually it appeals is what is registrable, but the functional element, see, this is also flat, this is also flat, but the way it has been put, the way you are seeing it is different. All three of them are tables. This is basic table which is flat, that's all. This has separate design elements to it, making it differentiating from the other tables which are regular tables. So what we are going to protect is the design of the table, but not the table itself. Okay, that is what is being communicated here as well. Again, a case, Escort Construction Equipment Limited versus Action Constructions Equipment Private Limited. Here, the Delhi High Court, again it is in relation to what is protected. The Delhi High Court has clearly communicated and said that to protect the shape and not the function, we are going to protect the design, we are going to protect the outcome, we are going to protect the visual appearance and not the function. It has been clearly held by the High Court in this particular case. Coming to what are the features of design. I have told you what is a design. We have seen the definition of design. What it should be one of the following: features, ornament, color combination, patterns, all put together. It should be put on a product. That can be 2D or 3D. It can be put on the product through a process, manual, mechanical or chemical, and ultimately when you see the final product, it should be visible. All these factors put together itself is the feature of design, where first, most important, when you see it, it should either be 2-dimensional or 3-dimensional. When you're seeing the product, either 2D image or 3D image. Okay, that is going to constitute a design. Shape, feature, configuration, pattern, how are you going to have the visual appearance? That is one of the feature of the design, that it can be any dimensional, 2-dimensional, 3-dimensional, 4-dimensional. Next, it is solely judged by the eye. What is the visual appearance? What is the ocular? Ocular means eye. visual? By seeing it, are you finding it different from a regular item? Is what we are going to see. We are going to judge by the eye. If by seeing the design we are saying that wow, this is so nice, this is so unique, then it is subjected to registration as a design. If it is something that is already seen before, something that is very casual, something that is there from many years, it is not a design. Something that is not new, you have seen this before, that wow element is not there, then it cannot be considered as a design. So what is the feature? It has to be judged by the eye. It should have a visual appearance. You should see something new, and that element is very important for registration as a design. Next, same thing. It's not only the mere ocular assessment, but also the appeal that is required. It should be appealing to the eye. People will want to buy the product merely by seeing it. If that element is there, then we say that it is a feature of design. Without an ocular appeal, there cannot be any design. Very, very important. If it is not pleasing to the eyes, it cannot get a registration as a design. Next. Again, distinguishing feature between functional attributes and design attributes. Functional attributes cannot be registered, whereas only protection is granted to the value that it is adding by the looks of it, by the appearance of it. Whatever value addition is being done to the product, only that is what is going to be protected. Now, there are two situations where there is only functional element but no appeal vision. In that case, we are not going to give protection. There is functional element, also aesthetic appearance. In this case, we are going to go and give ahead the registration as a design. So, two possibilities are there. The feature has merely functional element and no appeal. In that case, we cannot give the registration as a design. On the other hand, you have the ocular vision to appeal also. It is nice. It is satisfying all the functional requirements of a product. In that case, we are going to give it a recognition as a design. Proprietor of a new or original design, very important from the exam point of view. Who is the creator of design? Okay, who will have the right of his name to be entered in the register, that he is the owner of this design, he is the proprietor of this design. Okay, long list is there. Section 2 subsection J talks about the proprietor. I have just simplified it for you all to understand easily. Suppose I am the one who wants to create, okay, I have structured it, I have put it on the paper, but I don't know how to do that. Artistic work is required. I have imagined it should look like this, but I don't know how to do it. I have appointed a third person, a craftsman, I have given him instructions. See, this is the product, this is the design I want, you work on it, you make it for me. Right? So, in that case, I am the one who has conceived the idea. I am the one who has appointed somebody. So, even if the work has been done by somebody else, I am the person who conceived the idea. I am the one who has created the design. So, I will be the proprietor and I will be the owner of the design, and not the actual person who has manually or put that design into place, into physical appearance. So, what do they say? If someone makes a design for any other person and receives a consideration for making that design, the person who has directed the work to be done and the person who makes the payment will be considered as the proprietor. I have assigned the work, and because he is doing the work for me, I am giving him payment also. But he is doing the work. He will not be the owner of the work. I will be the owner, because on my instruction he has done it. I have given already a payment. He already has got the reward for his work. It is my idea and I will be the owner of the design. This is the first scenario where somebody has given the task of making a design to somebody else and is also making a payment for it. The person who conceived the idea and who started the entire process, he will be considered as the proprietor or owner of that particular design. Second scenario is when someone obtains the design or right to use the design either exclusively or in some other way. Assignment of design. Okay, when you are giving the right to somebody else to use it, the other person who has got the right will be the owner. I have created the design. Okay, I don't know how to commercially exploit it. I don't know how to market it. I don't have marketing channels. I do not have networking. My focus is on my strong point, or my strength is making designs. I focus one after one. How can I make more designs is my target. My previously made design should be exploited commercially. I should make revenue out of it. So I assign my design to somebody else. See, I have made this design. Now you put it out in the market. You put it out in the public domain. That work I have entrusted to somebody else. So the person to whom I have entrusted the work, to the person to whom I have assigned my design, the person to whom I have transferred my design, that person will be considered as the proprietor. So if I have transferred the right, the person who has the right to whom I have transferred, that person will be held as the proprietor of that particular design. Last category, in any other case where you have not completely transferred the right to use, or where you have not taken a person to hire, means you only have done everything by yourself, then any person who is the originator of the design, or any other person who has received the ownership and the right to use it from the original owner, will be considered as the proprietor. So person who has originally designed it at his own will, he himself is the proprietor, or if anybody has acquired the right for using that design, he will become the proprietor. So these are the various categories of ownership based on the situation of who is designing and who is getting the work done. Very important from exam point of view. Coming to the restrictions, what kind of designs are prohibited from a registration under section 4? Again, to simplify it, I have put it in the form of a chart. Something that is not new and not original, because when we are talking about the design, to see it should be wow, the factor that, oh, this is new, we have never seen this before. That element should be there, that visual appearance should be there. So if something that is ordinary, something that is not new, something that is not original, something that is already existing in the market, that is not capable of registration. So it should be new and it should be fresh, visually appealing. If it is not original, not new, we will not give you registration. Something that not significantly distinguishable from the known designs or combination of known designs. That kind of design is already available in the market. A lot of differentiating factor is not there. Visually it is different, but that visual appeal, what we call, is not there. It is slightly different, but that appealing factor is not there. Pleasing to the eye factor is not there. Then if it is not distinguishable from the already existing designs, we are not going to give you registration. Disclose to the public anywhere in India or any other country before the filing date. You have not got the registration for your product as a design, but already you are displaying your products in the exhibitions. Now you have a lot of exhibitions, flash sales, flash mobs, exhibitions are there, one-day exhibitions where you're going and displaying. All those people who are coming up with newer products are putting their products on display in exhibitions. If you have put your design element product in an exhibition without making an application for registration as a design, we will consider that your product is already out in the public domain, because you have already displayed it in the public, in a public exhibition. So if you have already put out in the public exhibition without obtaining registration, we consider it as a publicly existing product and we will not give registration. Comprises or contains any scandalous or obscene matter, something that is not decent to see itself, scandalous, obscene, okay, in that case we are not going to give registration. So 4 kinds of products are not registered if it is not new, not original, something that is obscene and scandalous, something that is not distinguishable from already existing designs, and something that is already put out in the public domain before obtaining the registration. On these 4 grounds, the registrar can say that no, your design is not eligible or capable of being registered as a design. Now for saying what is new and original, because we said that if your design is not new or not original, that is a ground for refusal. So what is new and what is original? If it has never been published before, it has been invented for the first time and it has not been reproduced by anyone anywhere. If these criteria are fulfilled, only then we say that it is a new product. If it is new, but you have already put out in the public domain in some exhibition, it does not remain new. It is not for the first time that people are seeing. In exhibition, people have already seen it. So, it is not going to be considered as new. Next, again, procedure for getting registration as a design. Again, it is very similar to what we have done for GI. You make an application to the registrar. Dating and numbering of the application is going to be done by the department. The department is going to examine that application. If there is kind of objection, they are going to communicate the objections to the applicant. If there are no objections to the application, they are going to accept the application and put it in the journal for the public to see. If public also has no objection, they are going to issue the certificate of incorporation. But if they have an objection, they are going to call for clarification. If they call for clarification and there is compliance, okay, then you're happy, your clarifications have been received, the registrar is happy with your justification, they are going to accept the application and put it in the journal. If there is no objection, they are going to issue the certificate of registration. You have called for, the registrar has called for objection, but you are not giving them the answer, there is no compliance, no reply, then we are going to treat your application as an abandoned application. You are not replying at all to the registrar. Other case, they have called for objection, you have given a reply, they've heard you out, but they are not happy with your answers, they are going to refuse. You can further appeal to the High Court if you are not happy with the order of refusal of your registration for design, right. So, in this case, they are going to, the various ways and routes are there, depending upon the design. Every procedure of registration is different. Sometimes right at once we are going to get the registration for design, sometimes there is going to be a lot of struggle that is going to be involved for getting the registration. So, this is the overall registration process, very similar to what we did for GI. Now, application for registration of design, section 5 says that controller will register the design if it meets the following criteria for a registration. Again, very similar to what we have already seen in the definition, something that has never been published before in any country, something that is not against public morality, decency and morality, and applicant claims to be the rightful owner of the design. It should not be copied. So, if these three factors are fulfilled, it is capable of being registered by the registrar as a design. The application is required to be submitted in a specific format. A form is there, you should just fill that particular form. Procedure is there, you should follow the procedure, and along with the application, whatever fees is there, that fees is required to be submitted. The design can only be registered in one class. Like for GI, we had various classes, it was permitted, but here in designs, only one class, one design can be registered only under one class. If there is any uncertainty about which class is applicable, where should I get myself registered, you can take the decision of the controller. The controller will have the final say, and whatever he says, his decision is going to be final. Whichever class he gives, that is going to be accepted by the applicant. The controller has the discretion to reject a design presented for registration on the 4 grounds that we have already seen. If he thinks that it is not capable of being registered as a design, he can reject the application. But again, basic things, right of being heard should be given before giving the refusal. They should call for objections and at least seek explanation from the applicant. And once they finally made a decision that no, we are not going to allow registration of this particular design, we are going to reject it, they can refuse the registration to the design. In that case, the person who is aggrieved by the rejection order from the controller, they will have a right to prefer an appeal before the High Court, saying that we had made an application for getting our design registered, but the controller or registrar has not given us the registration. So, we are appealing against the order, we want registration for a design. So, High Court is going to look into the application. Next. If the application is not completed on time and there is a fault in the applicant side, you have not replied at all, they have called for objections, they have called for information, you are not cooperating with the department for completing the formalities or procedures of registration, you are negligent, it is your fault, they can abandon the application and stop the registration process and treat the application as disposed of. They are not going to further deal with the registration process. Once a design is registered, it will be considered as registered from the date of application. So, whatever is the date of application, from that day itself, we are going to treat it as a registered design. Next, registration to be in respect of a particular article, right? Like I told you, they said only under one particular class you can get your design registered, and if you have uncertainty about that, the controller is going to decide. Same thing applies here. First one is class. Under class, you are going to have sub-provisions, okay. So, a design can be registered for one or more specific types of articles listed in the designated class of articles. If there is any question about which class your article belongs, where your product fits in, which is the right place for getting the registration, what category is the best for getting registration, then you can take the decision of the controller. He is going to make the final decision about which class is suitable, because n number of products are there, different categories are there. So you have classification of goods, classification of products. On that basis, which class is best suitable to your product, which class is best suitable for your article, you can decide on with the help of the controller. If the design has already been registered for one article with a particular specified class, the owner of the design can still apply to register it for one or more of the other articles within the same class. Like I told you, class is the major division. Under that you have sub-articles. So in one class, let's say class 51, article 5 is already registered. So in class 51 for article 7, you can seek registration. Okay. So in one class, multiple articles are there. If it is already registered in one class, you can seek registration as another article. When you have additional articles, it will not be refused or invalidated merely because it is already registered or already applied for previously. So now, like I told you, design and creativity element is an ongoing process. You have already registered one of your article in a particular design set. If you want to add additional features to the same design, you can do so, right, under the same article. They are not going to refuse the registration that already previously it has been registered, so we are not going to consider it. It is already previously registered, okay, but now we have added more features, we have added more visual appearance, we have enhanced the appearance, so that can also be registered even if it is previously registered. Additional features and additional designs can be taken into consideration. The most important thing is duration of protection. Whenever you are adding any additional articles or additional features or enhancing it, the period of duration is only going to be that of the previous registration. Initially, you have done a prior first time registration, that is applicable. So till the expiry is there of first registration, the additional features that you have added will also have the same old prior registration details. You will not have extra time for the new features that you have added. Whatever is your deadline or due date for registration, same thing will be applicable even for the additional things that you have added. What are the essential features of a design that are required to be present to get a registration as a design under Design Act? We have already covered. This slide is a sum of the entire concept that we have studied under the concept of design. It should be new and original. It should not be published anywhere previously, not even in public exhibitions. You should have special features with respect to shape, configuration, color combination, ornamentation, etc. It should be applied by the way of an industrial process that can either be manual, mechanical or chemical. It should be visible in the final product that is there. The visual, all these other above mentioned points should be visually appealable in the final product. It will not be considered registrable if it is a merely mechanical device, if it is a trademark, property mark or artistic work. In simple, essential requirements are the definition of design itself. On the basis of definition itself, we have arrived at the essential requirements. Next, publication of registered designs. Again, the controller is going to get an application, they are going to see through it, and if they think that they have no objections, they are going to put it available for public inspection for their objections. If anybody from among the public wants to make an objection, they can make. If they don't receive any objection, they are going to proceed further with the registration process. Now, you have made an application as the owner or proprietor of the design. We already have seen who is the proprietor of design. Originally, when you made an application for getting registration as a design, only my name was there as applicant. Now I want somebody else's name also to be included, or I don't want my name, I want my sister's name to be added as a applicant. So we can make that substitution. Name of the applicant can be substituted, or in addition to your joint claim. Earlier only A was there, now you are adding B also as an applicant. Earlier A was the applicant, now you want to substitute A with B. What is this? A had made the application, now you don't want A, you want B to be the applicant. That is substitution. What is joint claim? Earlier only A had made the application, now in addition to A, you want B's name also to be included in the list of applicant, right? So yes, it is permitted. The name of the applicant can be substituted. The name of the applicant along with a joint claim can be made only if the following requirements are met with. What is it? Claim. Before the registration has been completed, before that you should apply for substitution or joint claim. If the registrar has already issued the certificate, after that you cannot make an application for substitution or joint claim. Okay, before the registration process is complete, you are required to make this application. Right of claimant shall be created only by an assignment or an agreement. You are creating a joint name. Okay, you are giving your right to somebody else. In that case, it should be clearly written what is the agreement, what are the terms and conditions, what is the terms of assignment. Everything should be documented. The design under consideration should be clearly identified. With respect to which design are you giving this joint claim, that application number, because application is first submitted. After application is submitted, you want to make changes. So what is the initial application number, right? That unique number they'll give for registration. That number you should clearly specify in the agreement or the assignment, saying that for this particular design, I want this also person to be a joint claimant. So clearly you should identify which is the design with respect to which you want to give substitution or joint claim. And the rights of the claimant should be clearly established by the court. Right? So if these conditions are satisfied, only then the controller or the registrar is going to accept the application for substitution and the joint claim made by the applicant. Whenever you want to submit an application for substitution or joint claim, it is going to be done in form number 2, and only if the requirements are satisfied and the controller is also satisfied that everything is proper, the controller is going to direct that we can issue the application and continue the further registration process, either in name of the changed or substituted claimant, in the joint names of multiple claimants that they have added, or as the case may be with the consent of the applicants. Next, in case of joint applicant, okay, the joint applicant dies before the design has been registered, before the certificate has been registered, before that only one of the person who is making an application for the registration of design dies. In that case, we are going to continue with the application in the name of the people who are surviving. Whoever is left, in their name only we are going to continue the registration process. But for this, one essential condition should be satisfied, that the person who died, his legal representative's consent is required to be taken, that we don't mind, yes, my husband or yes, my father was a joint applicant. It's okay if you continue the registration process in the name of the survivor. So that consent should be obtained from the legal representative of the person who has died. In case there is any dispute between the joint applicants, okay, in that case, the controller is going to issue the directions and solve the disputes, but opportunity of being heard should be given to both the parties. Without hearing the party, you cannot give a favorism cannot be done. Biased judgment cannot be done. If there is a dispute between two parties, the controller should call both the parties, hear both their situations, what is their story, what is their side of justification, and only after that give a final judgment as to whose name we are going to further proceed with respect to the application of design. Certificate of registration, all this procedure is completed, all the criteria are met, public inspection is done, you have put it out in the journal, no objections, no cross counter questioning, nothing is there. If everything is proper, certificate of registration is going to be issued by the controller. In case you lose the original certificate that has been given, you can make an application for getting a duplicate certificate to the registrar. Again, that will be done at an additional cost and additional fees by the department. What is the effect of registration? What is the impact of registration? The owner of the design is granted the copyright in that design, and nobody else will be permitted to apply that design to the product that has been protected. So the copyright here refers to the exclusive right to apply the design to the article within that registered class. So under whichever class you have sought registration, only with respect to that article you are going to get protection, and you will have the sole and exclusive authority to deal with the design of that particular commodity. So that is the protection, that is the impact that you are going to have. It is also going to help in creating a distinguishing factor. Just by seeing the design, we can know, okay, this belongs to this particular organization. Register of design is required to be maintained. So as soon as a certificate of registration is given to any design, that has to be entered in the register of design, that is required to be maintained by the patent office. So again, patent and design always go in hand, right from the beginning. These two concepts have always been together in the single enactment. So the controller of patent itself will be the controller for designs. So whatever work with respect to design is going to be done, it is not going to be done by the registrar of trademarks or registrar of copyrights, it is going to be done by the patent office. So the controller of patent office will be in charge of all the work in relation to the designs registration. Content of the certificate will be the name of the design owners, the notification of design assignment. If you have given transferred it to somebody else, the details of that transfer, notification of transfer, any other prescribed details. This register of designs can be kept by the patent office either in physical copy or in electronic form. Even if it is in electronic form or physical form, basic safeguard should be there, that it should not be tampered, it should not be damaged. All those basic requirements are required to be taken care of when you are maintaining a register. And if once your name has been registered as a registered design, it is a strong evidence that everything has been complied with, that everything is in accordance with the law. So it acts as a strong evidence for any matter that is required to be published in relation to the matters in relation to design. Restoration of lapsed design, again we know that it is for a particular fixed duration of a time. At any point in time you forget to renew your design, you forget to make an application for renewal of your design, we have an option for restoration of lapsed design. On continual basis, if you are renewing, it is in existence, but you have forgotten to register, 3 years are over, next you want to use the same design, you want to seek registration for the same design, okay, then you are going to make an application for restoration of a lapsed design. They say that if the designer's copyright has expired due to non-payment of the extension fees or renewal fees, then the legal representatives can apply for the restoration only within 1 year from the date from which ceased to be protected. So you can restore it within a maximum of only 1 year period. If 2 years or 3 years have elapsed, then forget, you have to make a fresh application and you will not get it because earlier it was already into existence. So if you have forgotten to pay the renewal fees, you have a maximum of 1 year time to pay it and get back the registration of design. If 1 year period elapses, forget it, you are not going to get the registration of design ever again. Where multiple individuals are there, one or more of them can make an application. If there is a fight, instead of letting it lapse, any one of them can make an application for getting it revised and renewed. But when only one of them is doing without the consent of the other, you need the permission of the controller. That's see, we both are joint holders. I'm telling him that we need to apply for renewal, but he's not showing interest. I try to convince him he's not interested, but I want to continue the registration. You please give me the renewal for further extension. In that case, the controller's permission is required. If he gives the permission, then we are going to further renew it for further period. Application, it should be given a verified statement should be attached with this statement, giving them reasons of why, what were the circumstances because of which you did not pay the renewal fee on time. Why did you let your design lapse? Give a justification for that. Give a statement. Give us reason. Why did you not renew it within the time? Why is there a need of restoration of lapsed design? Why is there a need for restoration? Why did you let it expire? Is the justification that is required to be attached along with the application for a restoration of design. Now, cancellation of registered design. Already we have given you the registration. On certain grounds, the registration can be taken back. What are those grounds? It does not satisfy the requirement of design. Okay. It does not satisfy. So we are going to change. Not eligible for registration. Lack of novelty or originality. It is already published somewhere in India before, or it is already registered in India. Any one of these grounds, we can cancel the petition or cancel the request. You have made an application, somebody else is raising the objection, that is also possible. What is piracy? Piracy is duplicate. It is not an original product, right? Pirated movies, all of you will be well aware of. One is theatre print, available in the theatre. You should go to the theatre and watch. Next one is assigned. The producers of the film are going to associate themselves with some TV channel, some broadcasting channel, some OTT platform to put the movie out in the public domain. Only 2 channels are there, either theatre or broadcasting channels. Outside these 2 ambits, somebody illegally take a theatre print and put it on the internet. That is pirated version. It is not authorized, not legally put in the public domain. Illegally they put it in the public domain. That becomes piracy. So what is piracy? Piracy is the use of any intellectual property without the permission of the owner. that itself is piracy. So unauthorized reproduction, distribution or use of any kind of intellectual property without the permission of the owner is going to be piracy. It involves illegal copying and sharing of things like movies, software, books or any other creative work. Violation of intellectual property can result in legal consequences if it involves unauthorized use of intellectual property. If you are without permission using the work of any person, that involves piracy and violation, and that is subjected to penal provisions under the intellectual property laws. Piracy of a registered design. If the design is registered as a design under Register of Designs with the Patent Office and somebody is actually using it, somebody is applying your design, somebody is imitating your design and they are trying to sell such articles by using your design, then we say that there is piracy of the designs that are registered, and that is a punishable offence. Same thing, if somebody is applying or causing to be applied the design that has been protected, or somebody is trying to import the articles which are similar for the purpose of selling it, or somebody is publishing or displaying or causing to be published those articles for sale that is registered without permission, then they say that there is piracy of registered designs. Now, industrial and international exhibitions, very important. We already saw one factor, that if your design is without registration already put out in the public domain in public exhibitions, your article is not permitted or does not fulfill the criteria for seeking registration as a design. So, in relation to that, they are saying that if a design or an object with a design is shown at any exhibition which is approved already by the government. So, what you are doing it, you have not made an application for design, but you know in future you are going to make an application for design. So, before making a publication in the exhibition, you take the permission. So, what we call it as prior permission. You have obtained the permission that in future I will make an application for design, but today I am submitting it in an exhibition, I am displaying it in the exhibition. If you have taken the consent, if you have taken the prior approval, you can still go ahead and make an appearance in the public exhibition and later make an application for design. But if you have not taken the prior permission, you have displayed it in the exhibition, that in that case you will not be eligible for getting the recognition. Suppose you have taken the prior permission and you have made a display in the public exhibition, you will be eligible for getting a registration as a design. So, understand the importance of prior permission. If you have taken prior permission without making an application for design, also your design is going to be protected. If you have not taken the permission and you have displayed it in the exhibition, you are not going to get any kind of protection. But if you want this prior permission to be applicable, you should satisfy certain conditions. The first one is, you should inform the controller much in advance that you are going to exhibit your design in the public without making an application for design registration, and you should make an application for registration of design within 6 months from the date when it was displayed in the exhibition. Prior permission is valid for 6 months. Within 6 months, if you submit the application for registration of design, we will accept it as a design. But today, okay, today you have displayed it in the exhibition. You have not submitted an application for registration, okay, but you have the prior permission. Prior permission is there. On the basis of prior permission, you have displayed your commodities in a public exhibition, correct? Now, 8 months are over. Still you have not submitted the application to the controller for registration. In that case, even if you have prior permission, your commodity will not be eligible for getting the design registration, because you have closed 8 months. Mere 6 months time is given. Within 6 months of displaying your products in an exhibition, you should make an application for getting the registration. If these two conditions are satisfied, only then prior information and display in public exhibition will be permitted. If not, it is not eligible for being registered as a design. Now, industrial and international exhibitions continuing. Now, if somebody else shows your design or publishes your products in an exhibition without your permission, in that case, it is not going to impact the registration of design. Somebody has defrauded you. You are the originator of the design. You had thought you will make an application for registration of design, but without me knowing, I did not know, okay, without me knowing, somebody else has taken my article and put it in the public exhibition. It was not without my consent. I did not approve it. So in that case, it is not going to impact my registration. The authorities are going to give me the registration. That is only in case I myself are being defrauded by somebody else. I will be protected. I will be given the registration for my design. So this applies only when third party is taking your product and putting it in public exhibition without a permission. Then this is going to be applicable. Your registration will still be safe. It is not going to impact the registration. Now, appeal to the High Court against the order if the controller has issued any one of these orders. Refusal for giving registration, order passed for cancellation of the petition on the grounds, has passed rectification petition, or has refused the registration on the grounds of public morality or decency. For any one of these grounds, if your application for registration of a design has been refused by the controller, the person who is aggrieved by the decision of the controller, they can appeal before the High Court against the order. Filing of an appeal provisions 3 months from the date of the order of the controller. Okay. The decision made by the High Court in the appeal will be final and conclusive. The High Court can take expert opinion while hearing cases on these matters. Coming to the question bank or question from this chapter relating to designs. First one is, what is the duration of registration of a design? Can it be extended? How can the registration of design be cancelled? Okay, 3 questions, 3 topics they are asking together. Duration directly answerable. Can it extended? Yes, it can be extended on renewal. How can the registration be cancelled? For various reasons or various grounds that we saw, it can be cancelled. Who is the proprietor of the design? State the prohibition of registration of certain designs. Again, 2 questions they have clubbed. One is about who is the owner of the design, that section, and one is prohibition, section 9. Next, Amit has designed a teacup having a hollow receptacle holding and for holding a tea a handle to hold the cup. Can Amit register under the Designs Act? Again, direct based on the matter that functional element cannot be registered. So, Amit cannot register a teacup with hollow and a handle. Would your answer be different if the teacup has a fancy shape or ornamentation? Yes. In the first scenario, merely for the hollow and the handle, he cannot get a registration because that is the functional element. But if he adds an ornament or a fancy element to it, it can be registered. So, that is the answer. So, this brings us to the end of this session. We have covered 3 important chapters from part B of the syllabus, that is intellectual property rights, with the questions that have been asked by the institute in the previous papers. All the best, study well for your exams. Just remember one thing, that you can do it, have this mindset and go for it. All the best and do well.